Swear or affirm the information you're about to provide this court is the truth and nothing but the truth, so help you God.
Yes, sir.
So I just want to make sure you understand what you're doing here today, and you've talked with your attorney, obviously, about this, understood that this will be a final resolution in your case. You're giving up the right to go to a hearing on this to contest all these charges on the violation of probation. You believe this is in your best interest?
Yes, sir.
Very good. Based upon that, the court will accept your plea. There'll be an adjudication of guilt if it's not already done so. There'll be a reinstate and modify the provisions of supervision, that the next 6 months will be on community control, with the remainder to be on regular probation, complete all the original requirements, and there'll be, of course, the ever-present additional fees and costs, $100 BOP. So this is not extending your probation, it's not expanding it more, it's just changing the nature of it, which is a lot higher supervision. So you need to be on your P's and Q's, get through this thing successfully.
Yes, sir.
Okay. Any questions?
No, sir.
Thank you.
Thank you very much, Judge. That's my case. May I be excused?
Thank you. Have a good day.
You too, sir.
Ms. Dudley, flip out. Okay, Mr. Swiatek?
Morning, Your Honor.
Good morning.
Glenn Swiatek for Christopher Goins. It's 22 CF 3123. Mr. Goins is in custody. I have some case law documents to show.
Court's reviewed your motion, just FYI,
Thank you, Judge.
but I don't know that I understand it.
On June 18th, Mr. Goins' pretrial release was revoked or seeking reinstatement. It was revoked based on contact with a minor, which was ordered.
So was that a condition of the release?
Yes.
And then there was an allegation that he violated the terms of the release provision and Judge Ward revoked it?
Correct.
Okay. I just wanted, I didn't know if it was another new law charge or what. I wasn't exactly
Well,
clear.
there is, but there is not for today, not for our purposes. The only reason that it was revoked was the inappropriate contact with the minor, which was alleged in the affidavit by Ms. Croft, which I provided to the court.
Okay. So what's your argument? Your argument is the court doesn't have discretion to do that, that they didn't exercise their discretion properly? I'm not clear what.
The argument is that when you're revoking pretrial release, it's similar to a revocation of probation. It can't be based solely on hearsay. And in this case, we've got triple-tiered hearsay. We've got neighbors that there's been an ongoing feud with, telling law enforcement they have a video.
Okay, hold on, let me go ahead and read this, because I didn't have the benefit of this before. And what is the mother's name? But that doesn't matter.
Yeah,
Go ahead.
I'm not sure. It's not even listed in the affidavit. And the affidavit, as I was starting to say, is based on triple-tiered hearsay. An alleged video that the mother told law enforcement about, law enforcement told pretrial services told the court. Nobody's seen the video, and I haven't been provided it. There are some more facts in the case, which Ms. Basow let me know this morning, an affidavit by Mike Evans.
Did what?
An affidavit by Mike Evans, Officer Evans, Investigator Evans, with some more facts in it, but it doesn't change the argument, and that was provided to me this morning.
Okay. Ms. Basso?
Your Honor, first of all, the pretrial supervision was revoked based on an affidavit that was provided to Christina Croft, the supervising officer, by Investigator Mike Evans. I was able to obtain a copy of that yesterday. I did provide a copy of that to Mr. Swiatek, but that was actually the basis for her revoking, or her filing the motion to revoke pretrial release. Investigator Evans's affidavit is also based on reviewing the video.
Do you have that? Can I?
I do have a copy for the court, yes, I do.
Yeah, I'm going to just
And Your Honor,
And there's no evidence.
in some ways, it's actually...
let her finish.
May I finish?
Yes.
It's a two-page affidavit, Your Honor, it's a copy of what Mr. Swiatek had.
Okay, hold on a second. Let me just look at it real quick. Go ahead.
Your Honor, like I said, Ms. Croft based her violation, or her request to violate pretrial supervision on that. Additionally, I have spoken with Ms. LaQuay, Ms. Croft, to supervise Mr. Goins. There are concerns about his complying with supervision because his GPS monitor points keep showing that he's at or near that property that he's not supposed to be on.
Objection.
Your Honor, additionally...
But that isn't the basis of the...
No, it's not the basis, but I would point out to the court that Mr. Goins, even if the court sets this aside, Mr. Goins was also charged with a new law violation, a misdemeanor violation of injunction for stalking for that same property, and also criminal mischief for setting the fence on fire. Those events occurred later that same day. So we do have a new law violation as well, and we would ask the court to revoke his bond based on that, and we would make an order tennis motion for that particular basis. Additionally, I did speak to, there are concerns for supervision with Mr. Goins. Like I said, his points keep showing him at or near that property on the GPS. When he was picked up, first appearances, there was a question as to his GPS monitor. It could not be located. Mr. Goins indicated to the first appearance judge that Walton County had cut that off. Checking with Walton County by pretrial.
Hearsay.
Walton County said they didn't cut it off. So I'm just voicing the concerns the pretrial has. The biggest thing is he's got a new law violation of injunction.
And the injunction was not served until after the events that Ms. Basow has brought to the court's attention.
Okay.
But it's totally irrelevant anyway.
So the fact that there's a new law charge doesn't make him liable to have his pretrial bond revoked?
It could, but that's not why we're here.
Okay. And
here.
I'm not,
Yeah, we're here because,
well, let me just ask, just from a purely technical thing. His claim, Mr. Swiatek's claim, is that this information is hearsay, and you cannot use hearsay only in order to revoke a bond.
Your Honor,
I've not dealt exactly with that scenario, and I'm just wondering what your,
and that's what the case law.
let her,
Your Honor, we do believe in this case, the
is
probation...
this a revocation of bond, the case you cited?
Pretrial supervision.
Okay, so it's on all fours.
Yes.
Your Honor, Investigator Evans's affidavit, sworn affidavit that was provided to Ms. Croft, it's a sworn affidavit based partially on personal knowledge because he did review that video in preparation of his affidavit, the video that showed Mr. Goines making the contact with the child.
And there's
So
no,
we do believe that is personal knowledge of the officer attesting to what he personally observed when he was provided and was observed.
There's no-
And that's what Ms.
Can you let her finish, Mr. Swiatek?
I'll try.
You'll try? Please do it.
And that's, Your Honor, what Ms. Croft was basing her revocation on, the sworn affidavit provided by Investigator Evans.
And there's no evidence of that at all. The only evidence,
What do you mean there's no
About Mr.
evidence of that? Well, no evidence of what?
of Mr. Evans, of Investigator Evans's affidavit, which was provided to me this morning for the first time. The court never saw, Judge Ward never saw that affidavit.
Okay. This isn't even a close call. Court's denying the motion, and if there was some procedural infirmity based on the provision of the affidavit before Judge Ward, the court's remedying it now, and if it isn't, and if it was infirm on that, the court will grant the ore tennis motion that based upon a new law charge, the court's going to revoke the bond. So put it all in there. You can bring it up on appeal. Here you go. This is not a close call.
I'd like for that to be
This-
part of the court record.
You can put it in the court record. It's in the, everything we do is in the court record. You want this?
No,
Okay. Oh, you want this to be admitted?
yes.
So what do you want?
Miller,
You want the case law to be submitted to the court?
yes, sir.
I don't mind.
Objection, Your Honor.
Okay.
Mr. Swiatek.
And then you also want the Mr. Evans affidavit, you want that a part of the court record also?
That should be, yes.
I'm sorry?
That would be appropriate.
Yes, please, Your Honor.
Okay. So we'll do, the affidavit will be the defense's Exhibit 1, and the case law will be the composite Exhibit 2.
Thank you, Your Honor.
Okay. Thank you very much. Ms. Dudley? Good morning.
The first one I have, I believe, is Mr. Crone, Keith Crone. They're going to do Miss Allen last, Your Honor, since she's the only female.
Okay.
Your Honor, this is Keith Crone in 24 CF 1155. We were set today for a motion to reduce bond. I spoken with the state and my client. State had agreed to, the docket shows possession. He's charged with conspiracy, a third-degree felony in count 1. The state would agree to a $20,000 signature bond on that count. Then in count 2, a $10,000 cash professional bond.
10,000?
Yes, sir.
State?
Your Honor, that's the current bond on count 2, so the state is asking that the bond amount remain the same on count 2, and that's the same amount that his co-defendants received on that charge. So the state did agree to this bond, Your Honor, based on his criminal history.
Okay. By stipulation, the court will reduce the bond on count 1 to a $20,000 signature bond.
Yes, sir.
And the bond on count 2 will remain the same.
Yes, sir, thank you. Yes, sir. McCoy. Your Honor, the next case I have is Jiren McCoy. He has 19 CF 2428, 20,
Which one?
McCoy?
McCoy.
Yes, sir. 19 CF 2627, 2628, 2629, and 2638. Your Honor, on Mr. McCoy, we kind of been going back and forth just trying to make sure we were able to figure out what he actually pled to. While the docket does show a lot of charges, we have figured out what he actually pled to. We do have a plea agreement, if we may approach,
You may.
and I do have a score sheet as well.
Thank you.
Yes, sir.
Would you announce the agreement?
Yes, sir. In order to be a admission to the violation of probation, an adjudication of guilt, time served, $100 VOP fee per case, revoke and terminate probation and cost of judgment. This is based on the amount of time he spent in Louisiana based on these charges.
Say
And the
again?
time he spent here.
It's based upon,
The time he spent in Louisiana and the time he spent in jail here, so that's why it's a time served plea.
That's
Gotcha.
correct, Your Honor.
so that's for all the violations?
Yes, sir.
You want to announce them just for the
Yes,
court
sir. So
record?
19 CF 2638, it's a violation of probation on 5 counts of burglary of an occupied conveyance. And 2629 is a VOP on 3 counts of burglary of an unoccupied conveyance, grand theft of firearm, and grand theft. And 2628 is a VOP from 4 counts of burglary of unoccupied conveyance. 2627 is a VOP for 2 counts of burglary. And then in 2428, it was a VOP for 1 count of burglary and 1 count of theft of firearm.
Mr. McCoy, would you raise your right hand, sir? Do you swear or affirm the information you're about to provide this court is the truth and nothing but the truth, so help you God?
Yes, sir.
So I just want to make sure you understand what you're doing here today and that you are in agreement. You've had all your legal questions answered. So you've talked with your attorney about it. I see you've signed the plea agreement. I just want to make sure you understand the legal ramifications because there's an adjudication of guilt, so it affects your record. Have you gone over all that with your attorney?
Yes, sir.
You understand that by entering this will be a final resolution of this matter here today?
Yes, sir.
Okay. And you entering this freely and voluntarily?
Yes, sir.
Okay. Well, counsel, got one little detail. And you got to get the defendant's signature. And you're okay, Ms. Dudley, with the score sheet?
Yes, sir.
Okay. And the state's in agreement with that?
Yes, Your Honor.
Thank you. So, Mr. McCoy, based upon that testimony and the court will accept this plea agreement, and for the 5 VOPs that were cited by the defense counsel and are part of the agreement, the defendant admits to the violation of probation. There'll be a $100 VOP fee per case, so there's 5 of them. You will get credit for time served. That's actually technically your sentence, is credit for time served, and the court will revoke and terminate probation. So you're done with your probation. All the fees and costs will go to a judgment. Okay, question?
Yes, sir.
Okay, thank you.
Your Honor, next I have is Tyler Merritt. Your Honor, Mr. Merritt is here in 21 CF 2937, 22 CF 2894, and 24 CF 522. That's not on the docket, but we are going to take care of that plea today, if Your Honor's okay with that.
Okay.
If I may approach, Your Honor, with a plea and a score sheet.
You may. Thank you. You're okay with the score sheet?
Yes, sir.
Would you announce the agreement?
Yes, sir. Mr. Mayor, we'll be entering a plea to the 24 CF 522 case. The state will dismiss 21 CF 2937 and 22 CF 2894. He will be sentenced as a youthful offender, withhold of adjudication. I believe the court costs are let's see, it's a weird number.
Here it says 548, is
Yeah,
that?
548, it's a different number than usual.
Okay.
548.
$100 cost of prosecution.
Yes, sir. And time served, I believe, on that count. And then cost to judgment, if, we
Okay.
did the youthful offender to maintain the withhold. He does not have any prior criminal history.
Okay.
And Your Honor, that is the state's agreement, Mr. Mayor's case.
So, Mr. Mayor, can you pay these court costs and fees in the next 90 days? Okay. Because I'll give you a little bit more time if you need it, because you need to pay those, because if not, they'll go after your driver's license. Okay? Okay. Very good. Would you raise your right hand? I just need to ask you a few questions. Do you swear or affirm the information you're about to provide this court is the truth, nothing but the truth, so help you God? Yes? We're actually taking this being recorded.
Yes, Your Honor.
Okay, so you just heard your attorney state the terms of your plea agreement, and I see those same terms are contained in the written plea agreement. Put your hand down. That you've signed. So I just want to make sure, have you read the plea agreement closely and gone over it with your attorney?
Yes, sir.
Had all your legal questions answered?
Yes, sir.
Importantly, you're making substantial resolution of this, but you're waiving the right to go to a trial. You always have a right to do that. You're waiving that right. Are you comfortable that that's in your best interest to do that here today?
Yes, sir.
Okay. And you are entering this freely and voluntarily?
Yes, sir.
Okay. Based upon that, the court will accept your plea agreement. And the state, an agreement
Yes, sir.
dismissing the two VOPs?
Yes, sir.
So the state has agreed to dismiss 21 CF 2937 and 22 CF 2894. Those are two violations of probation.
Yeah, they were-
They're new law.
Oh, they were new law?
There were new law cases that were still outstanding. Your Honor.
Okay, sorry.
It's okay.
New law cases.
Yes, sir.
And the single new law case that's going to survive is 24 CF 522. And there will be a withhold of adjudication on that count. The defendant will be sentenced as a youthful offender. Court will charge the $548 in court cost, $100 cost of prosecution. Got to pay within 90 days or it goes to judgment. And the actual sentence is credit for time served. So you'll be able to get out, but your sentence is actually how much time you've already served, so you'll be able to get out immediately. Okay? Okay. Any questions?
No, sir.
Okay, thank you.
Next I have is Damian Gelman, 22 CF 2552 and 22 CF 3063.
Which
He's-
case is it?
He's not on the docket, Your
It was an add-on, Your Honor.
Okay,
I filed a notice, I believe, last week. The clerk told me to go ahead and file it. It was an early plea, we get out today.
okay,
I'm the approach.
you may.
I did email your officer.
Thank you. And you're okay with the score sheet? Would you announce the agreement?
Your Honor, Mr. Beltran will enter a plea in 22 CL 2552 and count 1 to a lesser included possession of controlled substance, count 2, a lesser included possession of marijuana more than 20 grams, and 22, and then count 3, possession of drug paraphernalia as charged. And 22 CF 3063 to be lesser included possession of controlled substance, and count 2, a lesser included possession of cannabis more than 20 grams, and then count 3 to 11 will be dismissed. He will be adjudicated guilty. It will be $515 court cost per case, 18 months DOC on all felony counts, time served on misdemeanors, All cases in counts 1 concurrent. The parties stipulated that he has served 18 months, and he's eligible to be released today. He has been in jail for 19 months, I believe, and then 6 months to pay the cost and then go to judgment.
State?
Your Honor, that's correct. That's the state's agreement.
Mr. Beltran, would you raise your right hand, sir? Do you swear or affirm the information you're about to provide this court is the truth, nothing but the truth, so help you God?
Yes, sir.
So you heard your attorney state the terms of your plea agreement?
Yes,
And I see that those same terms are in your written plea agreement that you've signed. So have you gone over this, read it closely, gone over it with your attorney in detail?
Yes, sir.
You understand that by entering into this, there'll be a final resolution of this case? Obviously, I understand why. Looks like a good deal. But you are waiving the right to go to a trial to contest all these charges? You believe that's in your best interest to enter into this agreement?
Yes, sir.
And you have had all your legal questions answered?
Yes, sir.
Okay. Very good. Based upon that testimony, the court will accept your plea. There'll be an adjudication of guilt. First of all, as to the charges, 22 CF 2552, count 1 will be the lesser included offense of possession of a controlled substance. And count 2 will be a lesser included charge of possession marijuana more than 20 grams. And count 3 will be possession of drug paraphernalia in 22 CF 3063. It's the same two counts 1 and 2. Count 3 through 11 in 3063 is dismissed. So for all those that were not dismissed, for all the charges, there will be an adjudication of guilt, $515 in court costs per case. And the sentence, technically the sentence here today, is 18 months Department of Corrections on all felony counts. They'll run concurrent at the same time, and you will get credit for time served on all misdemeanors. The state and the defense stipulate that you've already served the 18 months, and therefore you're eligible to be released immediately as to anything related to these charges. Don't know if there's anything else, but as it relates to these, you're eligible to be released. State?
Your Honor, just for the record, the state does agree that Ms. Dudley's motion to suppress that was filed is well taken, but I believe the defendant agrees to withdraw that motion to suppress for the purposes of the plea today.
That's correct, Your Honor. We will withdraw the motion that's filed.
Okay. You understand that? You understand what they're saying?
Yes, sir.
Okay, very good. So all cases, again, all cases and counts will run concurrent. You'll have 6 months to pay all the costs, and then it goes to judgment, okay? Try and, if you can, try and pay before the 6 months so they don't go after your driver's license. Okay, thank you.
Samantha Allen? Yeah, this is Samantha Allen, 21 CF 2810. We're here today on a motion to set bond. How may I approach?
You may.
I did get the copies instead.
Okay.
In our first motion to set bond in front of Judge Brown, Judge Brown stated the reason he was denying the motion was based on the failure to report and that we didn't have any information from her father-in-law about her not moving, because that was our argument. I did provide an affidavit with the motion where he states that she never left the residence and that she still lived there and she can still live there when she is released, if she's released. I also provide an affidavit from David Pryor, who is her employer, about his efforts to get her to probation based on the fact that he would drive her. She didn't have any transportation. Ms. Allen had informed me that she was informed by her dad medical situation has deteriorated. So I included that in motion as well. She is asking if the court would set her a bond on this case, as she has been adamant she never moved from her residence. The failure to report was in the month of March, and that she did have COVID, and then when she was going to report, they told Mr. Pryor, never mind, she doesn't need to come in. She is asking that the court set her bond on this violation of probation, any conditions the court deems appropriate. She has no prior failure to appear, she's not a flight risk. But the concern last time was the fact that we didn't have any information from Mr. Phillips, and I did provide a statement from him stating that she did not move from the residence.
State?
Your Honor, the state does understand the evidence that's been presented to Ms. Dudley's motion. The state would note for the court's record that Ms. Allen also has another open case in 24 CF 1105, which is a part of those FDLE cases that the court had conducted pretrial detentions on, Your Honor. So because of that, in the VOP case, in the VOP that we're talking about today was pre-existing the 24 CF case being filed. The probation then filed an amended affidavit in June alleging this new law offense, Your Honor. So in addition to the issues that were in the original affidavit of violation of probation, there's now been a second amended affidavit alleging that she's committed a new law offense while on probation. So for those reasons, the state would ask that her bond remain.
What are the new law charges?
They are use of a two-way communication device and facilitated felony, trafficking in fentanyl, conspiracy to traffic in methamphetamine, and racketeering, Your Honor.
Your Honor, if I may, those charges were addressed at the first bond hearing because she was arrested for it, I think, maybe a week before that bond hearing. Yeah, well, almost a month before, and after she had been in jail for, I think, a month. So we did address that issue. The issue, Judge Brown said that the reason why he denied the bond was based on the failure to report. The state did argue about the new charges, but I will keep in mind that Ms. Allen wasn't caught with any narcotics, I believe. But when they did that warrant, she was in jail. We did argue that at the first bond hearing. The issue Judge Brown had was that we didn't have any information from Mr. Phillips because the allegation was that she absconded from probation. And she did not abscond from probation. As Mr. Phillips stated, she does live at the residence. So that issue did come up at the first bond hearing.
This is a little bit unusual because we're dealing with a prior ruling by a judge. You're making, and I'm not saying you're.
I understand.
It's just it's tricky. You're saying, well, this is the way, this is the reason why he ruled, and that's what he may have said.
Yeah,
I mean,
understand.
I got forget what's in your ruling. Yours is a well-founded. I mean, it's arguable at the very least. But with these serious new charges, that's not a close call. These serious new charges, and so that would involve the revocation of any prior bond, in my estimation.
Would you?
Because I've been, even though I haven't seen charges, I take the state at their word, but I have dealt with a number of these pretrial detentions. So I'm unfortunately all too familiar with the allegations, the serious allegations contained with this.
Yes, sir. I think you did handle Ms. Allen's, and you did not hold her on pretrial detention. You did set her bond on those counts. I think she had Ms. Graham as her attorney on that
Yeah,
case.
but this is a prior. It's the new charge. You can get those,
Yes,
and then the procedure is always to revoke the lengthier, the oldest charge. So, based on the new law charges, I'm not even going to address the issues here. They may be well-founded.
Yes, sir.
But based on the new law charges, I'm going to revoke bond based on the new law charges.
Would you do it without prejudice in case we get information on the new case, we can come back for a motion?
Absolutely.
All right, thank you, Your
I mean,
Honor.
I think a bond is always without prejudice. I
Yes, sir.
don't know that you have to put in
I
there.
just wanna-
I think you have a right to come back and
Yes, sir.
readdress it, particularly if there's new information.
Yes, sir.
I mean, that's generally what we're looking for on these type of cases.
Your Honor, I believe that's all I have.
Very good.
Thank you.
Let's see. I think you're right. That's all you got.
Yes, sir.
Thank you. Have a nice day. Mr. Nopes?
Mr. Cobb was out on bond on 23 CF 2669, and then he had a civil commitment order for child support that was entered, and they picked him up somewhere around May 9th or 10th on that civil commitment, and as a result, he gathered additional charges. They revoked his bond at first appearance on 23 CF 2669, which is what I'm here on. And then there was an outstanding warrant from something that happened after, that happened before the May 10th. It was like May 5th, a warrant that got served, and that doesn't, he went to first appearance and got a bond on that, but that first appearance, they didn't revoke any bonds. So that's kind of where I know that's kind of jumbled a little bit. But what's holding him in jail right now is the fact that his bond on 23-2669 got revoked.
And based upon your allegation, based on your motion, it's saying it was revoked because of a new arrest.
It was, absolutely, Judge. He was picked up on a civil commitment order.
Is that the new arrest? Is the civil commitment, or is it a new law charge? I don't know technically whether a commitment would be a new law charge, but
That was the first new arrest.
right.
They picked him up from his
Yeah.
house and then transferred.
That's what got him before the court on it.
Right.
I understand that.
And then prior to that, on May 5th, there's an allegation that he was driving recklessly or whatever, and
Well, was the new law charge, did that occur before or after this charge?
the new...
No, it's after. It's
Yeah.
obviously much after, because it's a 23 case and the new law charge is a 24 case.
But the events of the 24 CF 1260 case happened on May 5th, although they did not serve the warrant while he was in jail until the end of that month. His first appearance was May 29th on that charge.
Okay, I'm not sure I'm tracking totally, but let me just ask what the state's position is on that, maybe.
Your Honor, the state's possession is that his bond should have been revoked. In the 23 CF case, those are alleged to have occurred, and I'm sorry, I had the information just. in-
23 CF 2669,
Yes, Your Honor, that's alleged to have occurred in November 29, 2023, so he was on bond in that case, and both of the 24 CF cases, that's 24 CF 1090 and 24 CF 1260, occurred in May of this year, 2024.
The
So that-
1260, what is that charge?
Your Honor, that's fleeing and attempting to elude.
Okay, so there are two new law charges that occurred after 23 CF 2669.
That's correct from the state's position, Your Honor.
And as a result of that, what is the state's position regarding reinstating a bond on 2669?
The state would oppose that as he's committed to a new offenses while out on bond.
Unless you can give me some reason, I mean, as a general rule, even a single new law charge would result, now you're innocent until proven guilty, but the new law charge, you can't get a new law charge without probable cause, so that's sufficient to revoke bond. That's usually with one new charge. You've got two new charges, so
He'd like to say something, Judge.
you're welcome to say.
I understand, Your Honor. I'm not asking for any favoritism, but just recently, I sold I was been handling my mother's estate, and I just sold her property, and as August 11th to 30, I sold it basically on July the 12th. August 11th, the 30-day inspection period is up, and I have to have that home cleared. Your Honor, I'll abide by any terms or condition until then, or I'm not sure if it's even possible, Your Honor. I don't know. But I need to get that house cleared out because it's going to...
You're going to have to get some help from somebody on the outside.
I believe you, sir.
That's what I would
I
say.
understand.
You're basically asking for a furlough, and that,
No,
for
no,
reasons Mr. Nopes is well aware, it probably wouldn't be appropriate.
Yes, sir. Yes, sir. Yes, sir. I understand fully. I know.
Okay, we'll try and get somebody to help you. I know that's an important thing, and try and get that resolved. The court's going to deny the motion to reinstate. Mr. Harper, get a couple of years.
Judge, this is Brian Alexander. He's before the court on 24 CF 626 as well as 24 CF 1121. Let me have just one moment, Judge. I think we have a resolution in this matter. So, signing date. Apologize, Judge.
I think that's mine. Yeah, anything A30 is mine. I didn't. Do you have a score?
Judge, this is an admission to be adjudicated guilty. There'll be a modification and reinstatement of supervision with the added requirements of an anti-theft course, and he is not permitted to buy out the community service work. He needs to complete all outstanding requirements, terms and conditions, and assess all applicable court costs. You may approach.
You may state.
That is this
Thank you.
state's offer, Your Honor. And this is, I will get this state, the court a score sheet. This will not be a downward departure, Your Honor.
Very good. Mr. Alexander, would you raise your right hand, sir? Do you swear or affirm the information you're about to provide this court is the truth and nothing but the truth, so help you God?
Yes, sir.
So you heard your attorney state the terms of the agreement. You're admitting the violation of probation. Did you read the plea agreement closely?
Yes, sir.
Go over it in detail with your attorney.
Yes, sir.
Understand you're waiving the right to go to a hearing on this, contest all these things. This will be a final resolution of your case
Yes, sir.
of the violation. And you you believe this is in your best interest to do so.
Yes, sir.
Based upon that, the court will accept your plea. There'll be an admission by the defendant, and if not previous, there'll be an adjudication of guilt as to all charges. The court will modify and reinstate supervision, and there'll be an added requirement, same term other than that, but their added requirement of an anti-theft course, and also clarification and kind of a change that you cannot buy out community service center. You got to complete all outstanding terms and conditions, and you'll have all the applicable court costs that'll be payable during the course of the probation. Okay? Thank you.
Your Honor, I'm sorry to the court. I did misspeak. This is a downward departure, but it's based on a legitimate uncoerced plea bargain.
Okay. Thank you.
Judge, this is Mauricio Bonilla, number 13 on the docket. He's before the court on 22 CF 1558 Judge, there are depositions of the victim in this matter set for August the 2nd. If we can move this to the 8/14 pretrial, we'll be resolving it with a resolution or a trial that's.
Very good. We'll continue this matter until 8/14.
Judge, if I can address a waiver real quick, number 15 on the docket, Figueroa Diaz, 23 CF 2512. Judge, on that particular case, if we can set this for August the 12th, the state and I are in continued negotiations, but we're anticipating a resolution on August the 12th.
August 12th, he's not.
He's out of custody, Judge. There's a
Okay.
waiver of appearance.
So we'll continue this till 8/12.
Judge, this is Quincy Fuqua. He's before the court on 23 CF 2062 and 23 CF 2843. Judge, I've conveyed to the states my request for them to consider an offer. They have to get the victim input in this matter. The state attorney on this is newly assigned, so she's just going to inquire in that. Hopefully, we can get a resolution on 8/14.
Okay. So we'll continue this matter until 8/14.
And the next one I have, Judge, is Deontay Knight, number 18 on the docket. He's before the court on 23 CF 704 and 23 CF 1515. I've conveyed my position with respect to 23 CF 704. The state is going to inquire about the status of the victim in that matter. That may come to that might facilitate a resolution in all the cases. He's been approved for Phoenix House. We're trying to incorporate that into the resolution as well. We're asking to move this to 8/14. We're hopeful we'll resolve it that cycle, Judge.
Very good. We'll continue this until 8/14, both cases.
Judge, those are my custody. I have a couple out of custody that aren't present yet, if I could just pass them.
That's fine.
Thank you, Judge.
Let's go ahead and, we've got some no attorneys.
I had two pro se.
Let's do that. Let's do Brooks and then Croxton. Does the state have an offer in this case?
Your Honor, this case is assigned to Ms. Sharpless. If you don't mind, if I could just take a quick look at it?
Sure.
Thank you.
Okay, good morning, Mr. Brooks. This is case number 23 CF 2371. You're here today on a violation of probation. This is the first time up. With this new charge, essentially is a new charge. You do have the right to have an attorney appointed if you cannot afford one.
Yes.
Do you wish to have an attorney appointed?
Yes.
Okay, so state may have an offer, I don't know. You're welcome to talk to your attorney. Generally what we do, I'm going to put that aside for a second, we may deal with it, is the court I'll appoint the public defender. I'm going to enter a denial on your part. That'll preserve your right, give you a chance to talk to your public defender, and then we'll come back on our next cycle, August 15th. How are we looking on August 15th? 15th and 20th. Come back August 15th. All right. State?
Your Honor, at this time, I do not see an offer.
Okay.
I don't want to speak for Ms. Sharpless.
Okie dokie. So you'll have a chance to meet with your attorney.
This is Nathan Brooks.
Yes, it is. You have 0? You start using that. going to ask the same question on Croxton. If you have. Ms. Croxton, this is case number 23 CF 1861. This is your first time up on a violation of probation. That's what the new law charge is. You do have the right, with essentially is a new charge, to have an attorney. You cannot afford one. One will be appointed. Do you wish to have an attorney appointed before we do anything else? No, you don't want an attorney? State have an offer?
Yes, Your Honor. The state is offering, admit the violation of probation, court ordered to attend Keaton inpatient or Phoenix House, and comply with the aftercare requirements.
Okay.
Your Honor, if I may, just
You may.
given the content of the state's offer, if you consider appointing the public defender just so we can speak with Ms. Croxton about the offer, just because it's a little
Pretty
bit more
comprehensive.
involved
Yep.
than just admitting the violation.
You sure you don't want an attorney?
No. I'm good. So Keaton, for how long?
It's usually about a year.
It's inpatient.
I'll take it.
Okay. Very good. So why don't you just take your, we're going to hold you over a little bit, and then we need to get a written document, put it together, and we'll get it resolved.
Okay.
Okay?
Your Honor, there's also another individual with no attorney that's out of custody.
Yes, I was going to call him next. Is Carl Edwards here? Would you come forward, sir?
Your Honor, Mr. Carl Jeffrey Edwards is here on case number 10-0871. It is a violation of probation. He's unrepresented this time, Your Honor. The offer does involve Department of Corrections time. It's rather significant.
Very good. So, Mr. Edwards, as stated before, this is a new law charge. You do have the right to have an attorney appointed. If you cannot afford one, one will be appointed. Do you wish to have an attorney appointed?
Yes, sir.
Okay.
Yes, Your Honor.
So the court's going to appoint the public defender.
Just to clarify, Your Honor, it's a violation of probation on an old 2010 case.
Okay. Okay.
Thank you, Your Honor.
So, public defender, the court's going to enter a denial on your behalf, Mr. Edwards, to give you a chance to meet up with your attorney. We'll come back on August 20th at 9 a.m. to give you a chance to meet up with your attorney and kind of look at your options, okay?
Oh, thank you.
Okay. Okay. Ms. Farkas, you want to do yours? You're in custody? Sorry, I know you're doing two things. You want to do your in custodies, or you want to skip over for Mr. Gates, or you want to do yours, Mr. Gates?
I get one of these up, let's go to the Sparkers one, here.
I'm happy to go.
Okay.
I just want to get a pen for Mr.
Okay.
Edwards. But I'm ready.
Works is continued to 8:14.
8:15.
I'll double check.
Somewhere in August. Somewhere in August.
The Keaton.
Include the new case on
Chartrand, the first one, Chartrand.
24 CF 1523. Where I got charged.
Your Honor, Israel Chartrand is approaching 2022 CF 2721 and 2022 CF 3012. I've been speaking with the state attorney about this case, and we're working on a resolution. If we could have an additional continuance, I think that we'll be able to figure something out.
Very good. We'll continue this till 8:20, August 20th, 9 a.m.
Thank you, Your Honor. You said August 20th.
August 20th.
20th, thank you. He might, Your Honor, Slater Cole might not have been transported. That's okay. If we could, I don't know if you want to approach on this one, Taylor. Slater Cole, do you want to approach on it? Your Honor, if we could approach on
You may.
Slater Cole, thank you.
Please give us a call. We're here to help you out.
Congratulations, Crestview's very own Dixie Dan Powell of Powell Injury Law, for your recent jury verdict of $11.5 million for your client from a death and injury against an inflatable amusement company. Recognized in 2017 as one of the top 100 civil trial lawyers in the state of Florida, and Dixie is AV preeminent rated. Dixie Dan Powell works tirelessly for his clients, as is evident by this extraordinary verdict. If you're taking your case to trial, be prepared. Contact Dixie Dan Powell and Powell Injury Law, 850-306-2667.
Cyclone Bakery Cafe is 2 blocks from the courthouse on Crestview's historic Main Street. We serve handmade pastries, espresso, and lunch
Based
items.
on the
We're
discussion,
open
the court
Tuesdays.
will continue this matter until August 20th, and you can communicate with your client.
Thank you, Your Honor.
God bless you. Thank you, Judge. God bless you. Thank you.
Your Honor, this is Stephen Copeland, 2023 CF 1395. The state and the defense have reached an agreement. If I can approach with it. Let me make sure. My client has to sign it really quickly. There you go. Okay. Yes.
I do get some credit from university.
You want to get another chair on the end? You want to, then get your chair. You want to sit on the end, or you want to sit over there?
I'm sorry.
That's okay.
You got an extra.
Could you?
I'm sorry.
Okay,
Up there.
that's
That's
fine.
okay. Just sign up there.
Sorry, I got excited.
That's okay.
If I may approach, Your Honor.
Thank you. You announce the agreement.
Yes, Your Honor. In 2023 CF 1395, there are 2 violations of probation. In count 1,
Hold
admit
on,
the
hold on, hold on.
Oh, I'm sorry.
Cut and paste wrong here. You got to put the case numbers wrong. That's right, that's right. Don't want there to be any internal inconsistencies. That's why we go over them, right? Okay, thank you. Let's start again.
Okay, in 2023 CF 1395, there are 2 violations of probation. The first is a felony VOP and the second is a misdemeanor VOP. The sentence will be the same. Admit VOP, 9 months Okaloosa County Jail with credit for all time served, the 2 counts to run concurrently. Revoke and terminate supervision, $150 public defender fee, and $100 cost of prosecution. And I will add that Mr. Copeland will have 180 days to pay the fines after his release.
State.
That's the state's agreement, Your Honor.
Mr. Copeland, would you raise your right hand, sir? Do you swear or affirm the information you're about to provide this court is the truth, nothing but the truth, so help you God?
Yes, sir.
So you heard your attorney state the terms of the plea agreement, and it's contained in the written agreement that you've signed. So have you read this closely, gone over it with your attorney in detail?
Yes, sir.
Had all your legal questions answered?
Yes, sir.
Importantly, you're waiving some valuable legal rights. Just want to make sure you went over it with your attorney. You're waiving the right to go to a trial.
Yes, sir.
Force the state to prove their case. You believe this is in your best interest to resolve this without going to a trial?
Yes, sir.
Okay, and this, you understand this will be a final resolution of this matter?
Yes, sir. I got one question I'll ask my attorney. real quick.
Do that.
Yes, sir.
Did you get your question answered?
Yes, sir, she answered it.
Okay, that's all right. So do you have any other questions you have of your attorney?
No, sir.
You're entering in this freely and voluntarily?
Yes, sir.
Okay, based upon that testimony, states an agreement.
Yes, Your Honor.
Based upon the testimony, the court will accept the plea agreement. As to the felony VOP count 1, the defendant will admit the VOP. He'll be sentenced to 9 months in the Okaloosa County Jail. You will get credit for all time served, and will revoke and terminate supervision. So when you get out, you're done with your probation. The public defender fee and cost of prosecution, of course, always, you'll have 180 days to pay that. As to count 2, it's a misdemeanor VOP, but it's the exact same sentence. Admit VOP, 9 months, Okaloosa County Jail, with credit for time served. They'll run concurrent. They'll run on top of one another. They're not stacking them.
Yes,
so it's
sir.
a total 9 months credit for time served. Again, with this same, the misdemeanor, you'll revoke and terminate supervision. So it'll be done when you get out. Be clear. Okay, any questions?
No, sir.
Okay, you got 30 days to appeal this.
Thank you, sir.
Thank you.
I'll be good.
Your Honor, next is Gus Curley. There are 3 VOPs, 2022 CF 1028, 2022 CF 1532, and 2022 CF 1542. I'm going to have Mr. Curley sign the agreement that the state and the defense have reached. Sign it right there. This is the last page, right? No, she just signed.
Been great, thank you.
Of course.
Thank you, Lord.
If I may approach you now.
You may. Would you announce the agreement?
Yes, Your Honor. There was a previous adjudication of guilt on all counts. In docket 2022 CF 1028, count 1 is a misdemeanor VOP. Admit VOP, credit for all time served, revoke and terminate supervision, $150 public defender fee, $100 cost of prosecution. Count 2 is a felony VOP, admit the VOP, 11 months, 29 days, Okaloosa County Jail with credit for all time served, which will be concurrent to any other jail sentence. Revoke and terminate supervision. Count 3, similarly, admit, credit for all time served, revoke and terminate supervision. In 2022 CF 1532, count 1, misdemeanor VOP, admit the VOP, credit for all time served, revoke and terminate supervision, $150 public defender fee and the $100 cost of prosecution. Count 2, admit the VOP, 11 months, 29 days, Okaloosa County Jail with credit for all time served, concurrent, revoke and terminate supervision. In 2022 CF 1542, count 1, the misdemeanor VOP, admit, credit for all time served, revoke and terminate supervision, $150 public defender fee, $100 cost of prosecution. Count 2, admit VOP, 11 months, 29 days, Okaloosa County Jail with credit for all time served, concurrent as well, revoke and terminate supervision.
Your Honor, that's the state's agreement.
Thank you, ma'am.
Very good. Mr. Curley, would you raise your right hand, sir? Do you swear or affirm the information you're about to provide this court is the truth, nothing but the truth, so help you God?
Yes, Your Honor, I do.
So you heard your attorney state the terms of your agreement, and I see those same terms are in the written agreement that you've signed. So have you read this closely, gone over it in detail with your attorney?
Yes, Your Honor, I have, and praise, and I thank y'all very much for your justice you've given me. I thank you very much.
So I just want to make sure that you're entering into this freely and voluntarily, and that you understand that this is a final resolution of this matter. You're waiving the right to go to a trial.
Yes, Your Honor.
Okay. You believe this is in your best interest?
Yes, sir.
Okay.
That's
Based
what I
upon
get.
that testimony, the court will accept your plea here today. I'm going to simplify it a little bit, summarize your sentence. You have 4 misdemeanor violations of probation. All of those, the sentence is credit for time served, revoke and terminate probation. So
God
you're
bless
done
you.
with those.
Thank you so much.
Okay?
It's trying to
Now-
be bad to my son. Thank you.
The felony violations, there's 3 of those, and those will also be identical sentences, and you're admitting the VOP on all these counts. But for the felony VOPs, you're being sentenced to 11 months, 29 days in the county jail, credit for all time served, revoke and terminate supervision. So, and these will be all concurrent with each other.
Yes, sir.
Okay,
Thank you.
so all
Good.
these will run at the same time. So you have a total 11 months, 29 days, but you'll get credit for all time served. When you get out, you're done with your probation.
Thank you, Your Honor.
You
Yeah.
got the fees and costs. Didn't put it in here, but you'll have 180 days to pay those.
All right. I
Okay,
can
give
pay
you
that.
some time. After you get out, you have 180 days to pay.
Can I
So-
pay it while I'm in jail? I can have it?
Absolutely,
Yeah, yes, sir.
absolutely. You can pay it.
I was asking, Your Honor, I'm a contractor, and I talked to Lieutenant Oliver down at the jail. They got some manners down there. I'd be happy if they asked me to ask. I could be trustees, I could be down there, some help. I
Okay.
can make up some time for what I did.
Sounds good. Okay.
Thank you,
Any
Your Honor.
questions?
No, thank
Okay,
you.
thank you very much.
No, thank you, ma'am. God bless you.
You bet.
Thank you for what you bet.
See you later, Mr. Perry.
Thank you, Your Honor.
You're welcome.
Your Honor, this is James Feckety, 2024 CF 1036. There is one case in front of you. I'm going to have Mr. Feckety sign the agreement that the state and the defense have reached. I can put the date, yeah. Okay. If I may approach, Your Honor?
You may. Thank you. Would you announce the agreement?
Yes, Your Honor. In 2024 CF 1036, there were 3 counts. Originally, count 1 will be dismissed. Count 2 is the misdemeanor DUI. There would be an adjudication of guilt in this count. 11 months, 29 days JCS probation. DUI school, 6-month driver's license suspension. substance abuse evaluation and treatment, 50 hours of community service that can be bought out at the statutory rate, 10-day vehicle impound, the victim impact panel, $500 fine, $300 in court costs, and the $150 public defender fee. Count 3 will also be dismissed.
That
as
is
part
the
of
state's
plea
agreement, Your Honor.
Has the victim been contacted?
Yes, Your Honor, the state is in compliance with Marcy's law.
Thank you. Mr. Feckety, would you raise your right hand, sir? Do you swear or affirm the information you're about to provide this court is the truth and nothing but the truth, so help you God? So you heard your attorney state the terms of the plea agreement. Those terms are in the written agreement that you've signed. Have you read this closely, gone over it in detail with your attorney?
Yes, sir.
You understand that by entering into this, there'll be a final resolution of these matters?
Yes,
But you're
sir.
waiving the right to go to a trial.
Yes, sir.
It's a valuable legal right. You're waiving that. You're comfortable doing that?
Yes, sir.
You believe it's in your best interest to enter into this agreement here today?
Yes, sir.
Nobody threatened or coerced you to get you to enter into it?
No, sir.
Okay. Based upon that, the court will accept your plea, and the state has agreed to dismiss counts 1 and 2 in 24 CF 1036. Excuse me, 1 and, did I say 1 and 2?
Yes, it's 1 and 3, Your
and
Honor.
3 are being dismissed. Count 2 is being admitted. The violation of probation is being admitted.
Your Honor, I'm sorry, it's not a violation.
It's a new law charge?
Yes, Your Honor.
Count 2 will be admitted. There'll be an adjudication of guilt on this count 2. The defendant will be sentenced to 11 months, 29 days of JCS probation. You must attend DUI school, 6 months driver's license suspension, substance abuse evaluation and treatment, it's important, 50 hours of community service, which can be bought out, 10-day vehicle impound, $500 fine, $300 cost, court cost, $150 public defender fee, and you must complete the victim impact panel. Any questions?
No, sir.
Okay. You may appeal this within 30 days.
Your Honor, this is Jennifer Diaz, 2023 CF 516 and 2023 CF 660. They are violations of probation. I'm just going to have Ms. Diaz sign the agreement that the state and the defense have reached. And Your Honor, if I may approach.
You may. Would you please announce the agreement?
Yes, Your Honor. In 2023 CF 516, these are all misdemeanor VOPs. Count 1, admit the VOP, 9 months Okaloosa County Jail, credit for all time served, to run concurrent, revoke and terminate supervision, $150 public defender fee, $100 cost of prosecution. Count 2, same sentence, admit VOP, 9 months OCJ, credit for all time served, revoke and terminate supervision. And I should have removed the costs and fees in that second count, as they only need to be assessed once per case. I'm sorry, 2023 CF 660, same sentence, count 1, admit the VOP, 9 months OCJ, credit for all time served, to run concurrently, revoke and terminate supervision, public defender fee, and cost of prosecution.
Go ahead and scratch this out, and also put in that she'll have 180 days to pay after she gets out. Is the state in agreement?
Yes, Your Honor, the state's in agreement with that.
You may. Thank you. Ms. Diaz, would you raise your right hand, please? Do you swear or affirm the information you're about to provide this court is the truth, nothing but the truth, so help you God?
Yes, sir.
So you heard your attorney state the terms of the plea agreement. I see those same terms are in the written agreement that you've signed.
Yes, sir.
Have you gone over it in detail with your attorney?
Yes, sir.
Had all your legal questions answered?
Yes, sir.
Importantly, you're waiving the right to go to a hearing on this to force the state to prove their case. This will be a final resolution here today.
Yes,
You
sir.
believe that's in your best interest?
Yes, sir.
And are you entering this freely and voluntarily?
Yes, sir.
Okay, based upon that testimony, the court will accept your plea. And these are, all three counts are misdemeanors. These are violations of probation, and as to each count, the defendant is admitting the violation of probation, and the defendant will be sentenced to 9 months in the Okaloosa County Jail. You will get credit for all time served, and these jail sentences will all be served concurrently, so all served at the same time, so
Yes,
they're
sir.
not stacked on top of one another. And all three, there will be a revoke and terminate supervision upon your release. And the public defender fee and cost of prosecution, and you'll have 180 days to pay the fees and costs.
Yes, sir.
Okay, any questions?
No, sir.
Thank you. Is this all the inmates you have? I think.
Oh, I have people for this afternoon. I was wondering why I still have people in my bucket.
Your Honor, there are a lot of out of custody shoot. One of us pop up.
Well, I was thinking that we should take a short break, and then we'll deal with all those. Ms. Sandler, which case are you here on? Are you here on just one?
I'm here on one case, Your
Which
Honor,
case?
Paul Ferguson. He was set for a change of plea today, but his probation officer, Ms. Mathis, will be amending his violation of probation.
If we could approach on Mr. Ferguson.
Sure. I was just trying to see if we can get that, if you only had one, to
Thank you, Your Honor.
kind of get it out of the way.
Cyclone Bakery Cafe is 2 blocks from the courthouse on Crestview historic Main Street. We serve handmade pastries, espresso, and lunch items, and we're open Tuesday to Saturday from 7 a.m. to 4 p.m., serving lunch from 11 to 2. We hope to see you soon.
Hello, I am Bonnie from Body Be Healthy here in Crestview. We have been serving the area since 1999. We're an alternative health food store. If you're interested in bettering your health, we'd like to invite you to stop by. We're located in Court Plaza. Stop by and let us help you be healthy.
I'm Amanda Gaskin with Briarpatch Realty. Helping qualified heroes save money is my passion. When I help a hero buy or sell a home, they receive a check from Homes for Heroes. Check out amandasheroes.com for more information.
For more than 70 years, the sweet aroma of the Crestview Coney Islands burgers and hot dogs has permeated the downtown area. If you have not experienced the unique flavor of Crestview's Coney Islands burgers and hot dogs, then I
So
encourage you to
Jamal
join us for
Ferguson,
lunch.
22 CF
Monday through
17 and
Thursday from
22
10 a.m.
CF
till 3
258
p.m.,
will be
Friday from 10 a.m. till 4 p.m., and Saturday from 10 a.m. till 2 p.m. We're located in historic downtown Crestview at 106.
I'm sorry? I have a criminal docket tomorrow. If you don't have any on your... Okay. I don't even know what to say about that. 'Cause anyway, we're going to take a short recess, and we'll come back about 10 minutes.
All rise, please. Court is in recess.
What do you have on at 2:30? 1:30. Maybe we should bring Greg, Johnny Greg, over tomorrow.
North Main Street. Call 850-683-1045.
CQ Roofing, your hometown roofer since 1999. We're state licensed and insured, family owned and operated with 24 years of local service. We specialize in shingles and metal, re-roofs, repairs, and leak specialists. For all of your roofing needs, call us today or visit our website at cqroofing.com. CQ Roofing, your hometown roofer.
Hey, I'm David at Family Vision of Crestview. We've been providing excellent optical service for Northwest Florida for over 34 years. Come in and let us take care of you.
Man, I got this. Let's roll. Fight fire with fire. Take one. Have you been injured in an accident and need righteous representation? Call us, because we fight fire. Damn thing ain't working. Whoa! Not cool, bro.
I'm Attorney Coy Browning. Personal injury is no joke. Just ask him.
Injured? Take a breath. Call Coy.
Check out the soaps, bath bombs, and other bath and body products, all made by hand with natural ingredients at Hub City Soapery. Visit us at 1092 North Verdon Boulevard in Crestview or shop online at hubcitysoapery.com. Hub City Soapery.
This is Tiffany Woodham, State Farm's newest agent in Crestview. I'd like to personally invite you to stop by my office for a no-cost policy review. Let me help you start saving today. Call in, walk in, or click in at yourcrestviewagent.com.
Alex Barthay from the UPS store once again, and I wanted to let you know about our Sunday hours. We're open now 7 days a week. Normal hours that you've been expecting, but now we're open Saturday 10 to 4, Sunday 10 to 3, and it's both our Crestview, Fort Walton Beach, and Eglin Air Force Base locations. So you have things to do, go and do it. Just know the UPS store is going to be here. Again, Sundays 10 until 3 p.m.
For years, I proudly served Florida as a state trooper. During that time, I investigated over 1,000 car, motorcycle, and trucking crashes. My mission was simple, to help the victims. Now, as an injury attorney, I can do even more to help accident victims. Hi, I'm Attorney Coy Browning. If you've been injured in a car accident, I'd be honored to help you. Call or visit us at browninglawfirm.com.
Hi, I'm Wanda Roberts. For the last 20 years, I've been helping the residents of Northwest Florida buy and sell their properties. My office is just 1 block south of the courthouse in historic downtown Crestview. Give us a call at 850-398-5389.
Hi, I'm Michael Gilbert, defense attorney with Warrior Law. I represent those accused in Santa Rosa, Okaloosa, and Walton County. If you or anyone you know has been accused of a crime, give us a call. We can help.
Hello, this is Chris Norman at Bulldog Bail Bonds. Our office is in Crestview, Florida, but we service 7 Northwest Florida counties. If you ever find yourself in a jam, please give us a call. We're here to help you out.
Congratulations, Crestviews' very own Dixie Dan Powell of Powell Injury Law, for your recent jury verdict of $11.5 million for your client from a death and injury against an inflatable amusement company. Recognized in 2017 as one of the top 100 civil trial lawyers in the state of Florida, and Dixie is AV Preeminent rated. Dixie Dan Powell works tirelessly for his clients, as is evident by this extraordinary verdict. If you're taking your case to trial, be prepared. Contact Dixie Dan Powell and Powell Injury Law, 850-306-2667.
Back Home Bakery Cafe is 2 blocks from the courthouse on Crestview's historic Main Street. We serve handmade pastries, espresso, and lunch items, and we're open Tuesday to Saturday from 7 a.m. to 4 p.m., serving lunch from 11 to 2. We hope to see you soon.
Hello, I am Bonnie from Body Be Healthy here in Crestview. We have been serving the area since 1999. We're an alternative health food store. If you're interested in bettering your health, we'd like to invite you to stop by. We're located in Court Plaza. Stop by and let us help you be healthy.
I'm Amanda Gaskin with Briarpatch Realty. Helping qualifying heroes save money is my passion. When I help a hero buy or sell a home, they receive a check from Homes for Heroes. Check out amandasheroes.com for more information.
For more than 70 years, the sweet aroma of the Crestview's Coney Islands burgers and hot dogs has permeated the downtown area. If you have not experienced the unique flavor of Crestview's Coney Islands burgers and hot dogs, then I encourage you to join us for lunch. Monday through Thursday from 10 a.m. till 3 p.m., Friday from 10 a.m. till 4 p.m., and Saturday from 10 a.m. till 2 p.m. We're located in historic downtown Crestview at 107 North Main Street. Call 850-683-1045.
CQ Roofing, your hometown roofer since 1999. We're state licensed and insured, family owned and operated with 24 years of local service. We specialize in shingles and metal, re-roofs, repairs, and leak specialists. For all of your roofing needs, call us today or visit our website at cqroofing.com. CQ Roofing, your hometown roofer.
Hey, I'm David at Family Vision of Crestview. We've been providing excellent optical service for Northwest Florida for over 34 years. Come in and let us take care of you.
Man, I got this. Let's roll. Fight fire with fire, take one. Have you been injured in an accident and need righteous representation? Call us. Because we fight fire. Damn thing ain't working. Whoa!
Not cool, bro. I'm attorney Coy Browning. Personal injury is no joke. Just ask him.
Injured? Take a breath. Call Coy.
Check out the soaps, bath bombs, and other bath and body products, all made by hand with natural ingredients at Hub City Soapery. Visit us at 1092 North Verdon Boulevard in Crestview or shop online at hubcitysoapery.com. Hub City Soapery.
This is Tiffany Woodham, State Farm's newest agent in Crestview. I'd like to personally invite you to stop by my office for a no-cost policy review. Let me help you start saving today. Call in, walk in, or click in at yourcrestviewagent.com.
Alex Barthay from the UPS store once again, and I wanted to let you know about our Sunday hours. We're open now 7 days a week. Normal hours that you've been expecting, but now we're open Saturday 10 to 4, Sunday 10 to 3, and that's both our Crestview, Fort Walton Beach, and Eglin Air Force Base locations. So you have things to do, go and do it. Just know the UPS store is going to be here. Again, Sundays 10 until 3 p.m.
For years, I proudly served Florida as a state trooper. During that time, I investigated over 1,000 car, motorcycle, and trucking crashes. My mission was simple, to help the victims. Now, as an injury attorney, I can do even more to help accident victims. Hi, I'm attorney Coy Browning. If you've been injured in a car accident, I'd be honored to help you. Call or visit us at browninglawfirm.com.
I'm I'm Wanda Roberts. For the last 20 years, I've been helping the residents of Northwest Florida buy and sell their properties. My office is just 1 block south of the courthouse in historic downtown Crestview. Give us a call at 850-398-5389.
Sure. I was as interested as you. Okay. How do we want to proceed? You want to do some out of custody?
I can, Your Honor.
Sure.
I'll start with I have number 30 on the docket, hopefully, Your Honor, Ms. Melissa Gibson.
Okay, hold on a sec here. Yes, that's correct.
You know, this is Ms. Gibson before the court. We left her as a status. We had her depositions yesterday. The 2 victims of the case didn't show, and the state made an amended offer in Ms. Gibson's case to a lesser included offense of count 1 and 3 years of probation. Outside that, she actually scored DOC. After speaking with Ms. Gibson this morning, she's asked basically if we could move for dismissal. So at this time, I'd like to continue the case to reschedule those depositions and then go from there.
Okay, so you want to come back August 20th? Is that a good time?
August the 12th, Your Honor.
Okay, you come back on the pretrial. Okay,
Yes, Your Honor.
very good. So we'll continue until August 12th.
Your Honor, next I've got is going to be Dayton Brad. Mr. Rack should be number 31 on the docket. Your Honor, this is Mr. Bragg before the court. The state and I have talked about some resolutions in this case. He's getting screened for a program. If we can continue his case to the August DOP date without subpoenas.
Okay. We'll continue to August 20th at 9 a.m.
Thank you, Your Honor. Yep. Next I've got is going to be Daniel Gaity, Your Honor. Should be number 32 on the docket.
Correct.
The state and I talked about Mr. Gaity's VOPs. He's in the process of getting some of those outstanding conditions completed. If we can continue his case without subpoenas to give him time to get that done.
So we'll continue till August 20th at 9 a.m.
Thank you. Thank you, Your Honor. You're good. Make an appointment, okay? So next I've got is going to be Richard Harter. Mr. Harter should be number 33 on the docket. I think the state has an announcement in this one.
Yes, Your Honor, the state will be dismissing the violation of probation, and probation will continue as is.
Very good. Thank you very much, sir.
Thank you, Mr. Case. You're welcome, Mr. Harper. You're very welcome. Thank you very much. Your Honor, next I've got is Gary Ivey. Mr. Ivey should be number 34 on the docket. We have a plea agreement to be filed in Mr. Ivey's case, Your Honor, if I may approach. It's going to be a modification of the state, so we'll be extortion on this.
Thank you. Do you announce the plea?
Yes, Your Honor. Mr. Ivey will be admitting the violation before the court in 23 CF 1415. He was previously adjudicated guilty. We're going to modify and reinstate his probation. Count 1, which is the felony count. The next 12 months will be on drug offender probation, curfew from 7 to 7, which can be modified by parole and probation for work purposes, followed by the balance of supervision on regular probation, monthly UAs, count 2, which is misdemeanor time served, complete original requirements. Mr. Ivey's currently enrolled in the medically assisted treatment program through Bridgeway. The state has asked that he continue with that treatment and finish that out. $100 cost of prosecution, $150 public defender fee.
That is the state's agreement, Your Honor.
Mr. Ivey, would you raise your right hand, sir? Do you swear or affirm the information you're about to provide this court is the truth, nothing but the truth, so help you God?
Yes, sir.
So you heard your attorney state the terms of your plea agreement, and I see those terms are in the written plea agreement that you've signed. So I just want to make sure, have you read this closely, gone over it with your attorney?
Yes, sir.
Had all your legal questions answered?
Absolutely.
You understand that you're waiving the right to go to a hearing, a trial on this matter? This will be a final resolution of this violation. Do you understand that?
Yes, sir, I do.
You believe that's in your best interest?
Absolutely.
Okay. Based upon that, the court will accept your plea. There was a previous adjudication of guilt in this case for today, and this, based upon this agreement, the court will modify and reinstate probation. In count 1, which is the felony violation, it'll be modified to include that the next 12 months will be a drug offender probation, and then followed by regular probation for the remainder of the term. As a part of the drug offender probation, curfew will be from 7 p.m. to 7 a.m., which can be modified based on work purposes. And then you also have the monthly UAs. Count 2, which is misdemeanor, get credit for time served. That's your sentence. You're finished with that. You're already enrolled in the medically assisted treatment program. You must continue that. That's probably the most important thing.
Yes,
How long have you been enrolled?
I've been active for recovery now for 90 days. I've been in the medically treatment program for going on 45 days now.
Okay.
It's been working really good. And I appreciate everybody in here giving me a chance to do this. Thank you.
Okay. Well, I'm glad. It takes effort on your part, too. It takes that commitment.
It does.
Just, get up every morning. You got to do it and have it
Just got to
focused.
stay sober, right?
Stay sober.
That's right.
Okay. Well, good. Glad it's going well with you.
Thank you, sir.
Any other questions?
No, sir.
Okay. Thank you very much.
Thank you. And that's all of my out of custody at this time.
Okay. Mr. Medina or Ms. Farkas?
Your Honor, I have Christopher De Silva, who's present and approaching, 2022 CF 1699. Your Honor, we have the state's offer. I need to discuss it with my client, and we have not yet had a chance to meet. If we could have a continuance to the next date so that I can speak with him.
No objection to that, Your Honor.
Very good. Court will continue this until 8:20 at 9 a.m.
The 20th?
August 20th, 9 a.m.
Okay, 29.
Here you go. August 20th. This is my office, okay? Okay, thank you. Your Honor, I also have Wade Downing, 22 CF 2407. I've just spoken with the state attorney, and we've worked out an agreement. If we could pass over Mr. Downing right now so I could write it up.
Very good.
Thank you.
Hang with us.
Your Honor, could I call Steve Medina for Keely M. Anon, A-N-N-O-N, on the morning docket? Keely Anon.
Okay.
22 CF 2733. We have an agreement that has been signed by all parties resolving her violation of probation. It was a underlying misdemeanor, so there is not a score sheet, Your Honor.
Very good.
And it was JCS, so I don't have to burden probation with a copy. May I approach, Judge?
Thank you.
Thank you. Your Honor, under the terms of the agreement, Ms. Anon in 22 CF 2733, she was previously adjudicated guilty. She's admitting violation. It would be revoke and terminate supervision, time served, $100 VOP fee, $150 public defender fees, outstanding monetary obligations to collections or lien in 6 months. State agrees not to file on FTA, if any.
State.
That's correct, Your Honor.
Ms. Anon, would you raise your right hand? Do you swear or affirm the information you're about to provide this court is the truth and nothing but the truth, so help you God?
Yes, Your Honor.
So you heard your terms of your plea agreement, and I see you've signed the written plea agreement. It says the same thing. Have you gone over it with your attorney, made sure you had all your legal questions answered?
Yes, sir.
You understand that by entering this will be a final resolution of this matter, and you're waiving the right to go to a trial?
Yes, sir.
And are you entering this freely and voluntarily?
Yes, sir.
Okay. Based upon that testimony, the court will accept your plea. You're previously adjudicated guilty on the underlying charge, and we are revoking and terminating supervision. Credit for time served, that's essentially your sentence is credit for time served. Got the fees and costs and monetary obligations. You'll have 6 months, and then it'll go to collections, and the state agrees not to pursue any FTAs. Any questions?
No, Your Honor.
Okay, good luck.
Thank you.
My other clients are inmates, Your Honor.
Okay. Mr. Harper?
If I may, I do have some out of custody that arrived. Can I call Candace Belton, number 14 on the bill? She was present and approaching.
I got it.
Judge, this is Candace Felton before the court on 23 CF 1688. She'll be withdrawing her previously entered plea and entering a plea of no contest, being adjudication of guilt, 24 months probation on count 1, 11 months and 29 days probation on count 2, $615 in court costs, $150 cost of defense, a substance abuse evaluation and any recommended treatments, evaluation within 30 days, treatment within 60 days, supervision concurrent. This is Falcon.
Yes.
Judge, the state will submit a score sheet later. This is not a downward departure.
Very good.
May I approach?
Thank you. What is your last note on here? AW supervision concurrent?
All the supervision is concurrent, Judge. The misdemeanor and the felony probation.
That's all. Okay, I just couldn't read the writing, sorry.
Oh, I'm sorry.
That's all right. Okay, Ms. Felton, would you raise your right hand, please? Do you swear or affirm the information you're about to provide this court is the truth, nothing but the truth, so help you God?
Yes, Your Honor.
So you heard your attorney state the terms of the plea agreement, and I see you've signed the written plea agreement that contains those. Have you read this closely, gone over it in detail with your attorney?
Yes, sir.
You understand, had all your legal questions answered?
Yes, sir.
Understand that by entering this, you're waiving the right to go to a trial. This will be a final resolution of this matter.
Yes, sir.
You believe that's in your best interest?
Yes, sir.
You're entering this freely and voluntarily.
Yes, sir.
Based upon that testimony, the court will accept your plea. There'll be an adjudication of guilt on both counts. The court on the possession of controlled substance, count 1, the court will be entering or ordering 24 months of probation. And on count 2, it'll be 11 months, 29 days, 11 months, 29 days probation as to count 2. Standard fees and court costs. You must get a substance abuse evaluation, that's important, and any recommended treatment. The evaluation must occur within 30 days and any treatment within 60. Do you understand all that?
Yes.
Now, just to be clear on this, the probation, is it concurrent or consecutive?
Concurrent for a total of 2 years, Judge.
Oh, it says that all supervision, that's where you had that. Okay.
Yes, sir.
So, clarify it. Okay. So these will be run together, so it'll be a total of 2 years.
Yes,
Okay.
sir.
Stay in good contact with your probation officer. That's the key to all this. Okay? Thank you.
Thank you, Judge. The next one is Erica Gray, number 17 on the docket. She is present and approaching. She's before the court on 24 CF 200. At this time, she's going to withdraw her previously entered plea into a plea of no contest. This will be a plea to a lesser included offense of possession of paraphernalia on count 1. Counts 2 and 3 would be dismissed. Should be adjudicated guilty, placed on 11 months and 29 days of probation, $270 in court costs, $150 cost of defense. Intend to complete a substance abuse evaluation and any recommended treatment. Evaluation within 30 days, treatment within 60. She is asking for probation with JCS. There is no score sheet because this is a misdemeanor.
You may.
That
Thank
is the
you.
state's agreement, Your Honor.
Thank you. Very good. Ms. Gray, would you raise your right hand, please? Do you swear or affirm the information you're about to provide this court is the truth, nothing but the truth, so help you God?
Yes, Your Honor.
So you heard your attorney state the terms of your agreement, and those same terms are in the written plea agreement that you've signed. Have you read this closely, gone over it in detail with your attorney?
Yes, I have.
Had all your legal questions answered?
Yes, sir.
You understand that by entering this plea agreement, you're waiving the right to go to a trial. It's a valuable right.
Yes.
You believe that's in your best interest to have a final resolution here today?
I do.
Okay. And you are entering this freely and voluntarily.
Yes, sir.
Based upon that testimony, the court will accept your plea, and there'll be, counts 2 and 3 will be dismissed by the state as part of the agreement, and you're pleading to a lesser included offense of possession of paraphernalia on count 1, and you'll be sentenced to 11 months, 29 days probation, standard cost and fees. Importantly, you must get a substance abuse evaluation and follow through with any recommended treatment. The evaluation within 30, and then start the treatment immediately in 60 days. Probation will be with JCS. Make sure and check in immediately on that.
Yes, sir.
Stay in good contact, okay?
All right.
Thank you very much.
Thank you, Judge. All right, you're good?
Yes, sir. Thank you.
Check them out.
I think that's all. you
I
got?
think I do have one more, Judge, number 12 on the docket, Chelsea Anderson. She is not present this morning. I'm not certain as to why she's not present.
Your Honor, the state has some information for the court. The probation officer has informed me that she has done yet another amended violation of community control for absconding. So I believe that's why Ms. Anderson's not present this morning. The state's requesting a failure to appear.
I have nothing to add to that.
Court will issue a no bond KPS.
Thank you, Your Honor.
Thank you, Judge. That's all I have today. I do have a hearing this afternoon.
Okay. Are you anticipating the motion to dismiss hearing to?
I don't, Judge. The state has filed its traverse.
That's what I was wondering.
Yes, sir. So
Can we get them in earlier and 'cause that's the only, we've got a 2:30. I've got some arraignments at 1:30, but 2:30, we've got one hearing, a substantial hearing, and then your case.
I will try to get him in at 2:30, Judge, since it'd probably take 3 minutes. I'll get that.
I kind of assumed, that's why I asked.
Yes, sir.
Okay, thank you. Mr.
Yes, Your Honor,
James.
if I can take Miss Jessica Jones on the 36 on the docket, Your Honor.
Okay. Very good.
Let the state sign that plea agreement, Your Honor, as well. I may approach, Your Honor.
Okay.
Here is a score sheet, Your Honor. This, Jones does score 14.1 months. The state's agreed to suspend that and put her on probation.
Okay.
I think I gave everyone the wrong one. And that one, but you had the one inside, Your Honor.
Okay, that'd be good. Thank you. You may announce the agreement, please.
Yes, Your Honor. Ms. Jones will be pleading no contest to a lesser included offense in count 1 and 21 CF 387. Adjudication of guilt, 14.1 months Department of Corrections suspended. Should be placed on 3 years of probation, waive the cost of supervision, $615 in court costs, $150 public defender fee, required to do a substance abuse evaluation within 30 days, recommended treatment within 60 days, random urinalysis, maintain gainful employment, or complete 3 job applications per week. And the state will agree to dismiss count 2 in exchange for a plea to count 1.
And that is the state's agreement, Your Honor.
Very good. Ma'am, would you raise your right hand? Do you swear or affirm the information you're about to provide this court is the truth, nothing but the truth, so help you God?
Yes, sir.
So you heard your attorney state the terms of your plea agreement. And I see those same terms are in your written plea agreement that you've signed. Have you read this closely, gone over it in detail with your attorney?
I have.
And you have had all your legal questions answered?
That's right.
Understand that by entering this, you're waiving the right to go to a trial. This will be a final adjudication of this case.
Yes.
You believe that's in your best interest?
Yes.
You've entered this freely and voluntarily.
Yes.
Based upon that testimony, the court will accept your plea. There'll be an adjudication of guilt on the lesser included charge on count 1, possession of a controlled substance, and the court will sentence you to 14.1 months, Department of Corrections. That sentence will be suspended. In addition, you'll have 36 months of probation, waive the cost of supervision, standard court costs and fees. You must importantly be evaluated for substance abuse within 30 days, follow any treatment, begin that within 60. So that's an important component of this.
Yes, sir.
You must have random UAs and gainful employment or complete applications. And in exchange for this plea, the state will dismiss count 2. Correct? State will dismiss count 2.
That is correct, Your Honor.
Okay. Do you have any questions, ma'am?
No, sir.
Thank you very much.
I think we're going right into in custody.
Okay.
The first one up is going to be Derek Jones. Should be number 35 on the docket.
Correct.
We have a plea agreement to be filed in Mr. Jones' case, Your Honor. It does include a plea case. My hope is that we were able to get that served and we can handle that. If you're not, will let me know if we can't.
Clerk, you check.
You can take care of it since he's served at the jail.
Okay. Okay.
Sounds like we can handle that today, Your Honor, then.
Okay, you may proceed.
Your Honor, Mr. Jones is going to be admitting the violation in 23 CF 2292 and plea as charged in 24 CF 568. He'll be adjudicated guilty on the misdemeanor counts, which is 23 CF 2292, and a withhold on the felony counts, which will be 24 CF 568. And 23 CF 2292, we're going to modify and reinstate his supervision. That'll be concurrent with 24 CF 568, required to complete the original requirements, $100 cost of prosecution, $150 public defender fee, and 24 CF 568, 24 months of probation concurrent with each count and case, waive cost of supervision, $515 court costs, $100 public defender fee, restitution the amount of $2,989.79 to Service First Bank, and then $397.52 to Navy Federal Credit Union, required to take the anti-theft course, which can be done online, maintain gainful employment or complete 2 job applications per week, required to do 24 hours community service work. The state's agreed to take no action on any FTAs associated with this case. And then Mr. Jones had asked if the court would have an objection to him transferring to Mississippi, and I told him he'd have to go through the process on that.
Yeah, that'll be by probation, but they have fairly standard procedures, but we can't make you any promises. Okay, Mr. Jones, would you raise your right hand? Do you swear or affirm the information you're about to provide this court is the truth and nothing but the truth, so help you God?
Yes, Your Honor.
State in agreement?
Yes, Your Honor, the state is in agreement.
Okay. So, Mr. Jones, you can put your hand up. So, Mr. Jones, you heard your attorney state the terms of the plea agreement. I see those same terms are in your written plea agreement that you've signed.
Yes, Your Honor.
Have you read this closely, gone over it in detail with your attorney?
Yes, Your Honor.
And you understand that by entering into this plea, you're waiving some valuable legal rights, right to go to a trial is the big one. You might just force the state to prove their case beyond a reasonable doubt.
Yes.
Do you believe that that's in your best interest to enter into this agreement, have a final resolution here today?
Yes, Your Honor, I do.
And you're entering this freely and voluntarily?
Yes, Your Honor.
Based upon that testimony, the court will accept your plea. As to the misdemeanor counts in 23-2292, there'll be an adjudication of guilt, and then the two counts, the felony counts in 24 CF 568. And there'll be a withhold of adjudication on both those counts. And as to the misdemeanor counts, the court will modify and reinstate your probation. It'll be you have to complete original requirements and then standard fees and costs. The probation will be concurrent. Basically, all of them will be concurrent with each other, but they'll be concurrent with 24 CF 568. And in that case, you'll be sentenced to 24 months probation, waive the cost of supervision, standard fees and costs. Importantly, you must pay the restitution that's contained in the agreement that was stated by your attorney, and you must complete an anti-theft course and maintain gainful employment or make applications every week, community service, and there'll be no action taken on any failure to appear associated with this case. Okay, any questions? Okay, thank you.
Your Honor, next should be number 37, Derek Jutras.
Which one?
Derek Jutras, number 37, Your Honor.
Gotcha.
Your Honor, we were able to negotiate a plea agreement with the state this morning in Mr. Jutras's case. If I could let him sign the plea agreement. While he's doing that, Your Honor, Your Honor, he was asking about his court costs, if I can look at the VOP affidavit just to tell him what was outstanding. So yeah, 665, 250, 370, 250 plus the surcharge, so you owe about $1,200. Can we get any of that worked out? I'm giving you 24 months to pay it. If you can't pay it, it'll go to collection. All right. But it gives you time to pay it. Why? Anything else? So I get all my credit. Everything. You good? It's on there. Your Honor, while Mr. Jutras is signing, I do want to ask the court to put on the minutes and have Madam Clerk put on the clerk's minute sheet that Mr. Jutras needs to be held in the county jail pending the restitution hearing. I don't want him to go to DOC and have to bring him back. The restitution was originally set in this case, and it wasn't Mr. Dina's case at the time, but Mr. Losco agreed that it had been set in error. Essentially, the state attorney's office sent an email saying, hey, this is the restitution. Mr. Jutras was not actually given an opportunity to have a hearing on that amount. And based upon my conversations with the state, they agreed to basically take that back and allow us to set a hearing to determine that amount as well.
Very good. So if the minutes will reflect that, he'll be held before he goes to DOC.
Thank you, Your Honor.
For the restitution hearing.
Hang on here for a second.
Got to ask you a few questions.
but it is, reflects a total score of 16.65 months DOC. So this is a bit of a downward departure for a little less DOC. If I can approach.
You may. So it's based upon uncoerced negotiation.
That's correct, Your Honor.
Would you announce the agreement?
Yes, Your Honor. Mr. Jutras will be admitting the violation before the court. He was previously adjudicated guilty. He'll be revoking and terminating outstanding probation, sentenced to 14 months Department of Corrections concurrent between all 3 counts, with credit for all time served. The state has also agreed to give him credit for time in Keaton. He successfully completed that program. So those dates would be from June 23rd, 2023 to January 4th, 2024, for an additional credit of 199 days total, on top of what he's entitled to from being in the county jail. $100 cost of prosecution, $150 defender fee, and then he'd ask for 24 months from his release date to pay those outstanding fees.
State?
That is the state's agreement, Your Honor.
Sir Jutras, would you raise your right hand, sir? Do you swear or affirm the information you're about to provide this court is the truth, nothing but the truth, so help you God?
Yes, sir.
So you heard your attorney state the terms of your plea agreement. You can put your hand down.
Yes, sir.
And I see those same terms are in the written plea agreement that you've signed.
Yes, sir.
Have you read this closely and gone over it in detail with your attorney?
Yes.
Had all your legal questions answered? Do you have any other legal questions? I'm not trying to rush you through this.
Not for you, but
You're welcome to ask him any.
You know, he was asking about some of the court costs, and I explained, I think the court has the option to allow community service work in lieu on some of them. And so he was asking if the court would consider allowing him as an option to work some of those court costs off. I don't know how much. I know there's set amount the court has to require as payment, but I know the court.
Those are always a little bit of a gray area, but I know the cost of the public defender is not allowed to be worked off, is my understanding, but the other ones. Whatever can be, the court's fine with allowing you to work it off, whatever is allowed by statute. So, again, you heard your attorney state the terms of the plea agreement, and you believe this is in your best interest to enter into this plea agreement?
yes.
And you have had all your legal questions answered of your attorney regarding this plea agreement?
Yes.
And you believe it's in your best interest to enter into this agreement?
Yeah.
And you understand you're waiving the right to go to a trial, force the state to prove their case?
Yes.
There'll be a final resolution of your case here today. You
Yes.
understand that?
Yes.
You're entering into this freely and voluntarily.
Yes.
Based upon that testimony, then, the court will accept your plea agreement. You were previously adjudicated guilty. The court will revoke and terminate probation. The court will sentence you to 14 months in the Department of Corrections for each of the 3 counts. They'll be served concurrent with each count, so it's basically one 14-month sentence. You will get credit for all time served, and additionally, you will receive an additional 199 days credit for the time you were at Keaton, as outlined in your agreement. You've got a standard cost of prosecution and public defender fee, and like I say, anything you can work off by community service hours, you're welcome to do so. Court will allow it, and you'll have 24 months from the date of your release to pay anything you haven't been able to work off before they're sent to collections. Okay? Any questions?
He had one for me, Your Honor.
Okay.
Thank you, Your Honor.
And one last thing, sir, you do have a right, even though you've just agreed to this, you do have a right to appeal this. You've got to do it within 30 days.
Yes, sir.
Okay? Thank you.
That goes here right there.
Ms. Farkas has asked to speak your out of custody. And
Oh, okay.
We'll be really quick. Wade Lee Downing is approaching. And I have a plea agreement, if I may approach the court.
Okay. Thank you.
Your Honor, this is 2022 CF 2407. It is one misdemeanor VOP count. There was a previous adjudication of guilt. Mr. Downing will admit the VOP. He'll be reinstated on JCS probation to complete the remainder of the outstanding requirements. $150 public defender fee and the $100 cost of prosecution. I had originally put in the specific terms, but we realized it'd probably easier to just say complete everything that's left and leave it at that.
Very good.
I think that's correct.
Mr. Downing, would you raise your right hand? Do you swear or affirm the information you're about to provide this court is the truth and nothing but the truth, so help you God?
Yes, sir.
So you heard your attorney state the terms of your plea agreement, and I see you've signed the written plea agreement.
Yes, sir.
Have you read through this, gone over it in detail with your attorney?
Yes,
You
sir.
understand this will be a final resolution in your case?
Yes, sir.
Waiving the right to go to a trial.
Yes, sir.
And you're entering this freely and voluntarily.
Yes, sir.
Based upon that, the court will accept your plea. There'll be an admission of the VOP. You were previously adjudicated guilty, so the court will reinstate JCS probation in order to complete the remainder of the outstanding requirements. And in addition, you've got additional fee, public defender fee and cost of prosecution. Very good. Any questions?
Yes, sir.
Thank you.
Thank you.
Oh, Your Honor, I'm sorry. Just briefly, Mr. Downing has an ankle monitor that was part of his pretrial services, his release on bond. I'm pretty certain that he needs to get it removed at their office.
It's above my pay grade. I have no idea.
Okay.
Once you ask probation, they can probably
Okay.
tell you right now.
I'll speak with them.
Thank you, sir.
You may have to go to Crestview for trial services.
I'll speak with probation.
Okay.
I mean, if we need to take a flight out there, I wouldn't. You know, this is Mr. Winrick Kill before the court in 24 CF 604. At this time, we're going to enter in denial on the violation of probation. He should be number 38 on the docket, Your Honor.
Okay. So enter a denial.
Yes, Your Honor.
Come back August 20th at 9 a.m.
What happened?
All right.
Well, I got to come back.
August the 20th. No. All right. All right, we're
Look familiar. I'm just trying to have.
It's never a good sign when you're familiar with the judge.
All right. You know, this is going to be Brandon Kelly before the court in 24 CF 1468. I moved him to today's date for a early plea. I have a plea agreement to be filed in his case, Your Honor, if I may approach.
You may.
I will say the file source sheet later, Your Honor, but it will not be a down report.
Thank you. Would you announce the terms?
Yes, Your Honor. Mr. Kelly will be entering a plea of no contest as charged. He'll be adjudicated guilty and all counts sentenced to credit for time served, $515 in court costs, $150 public defender fee, restitution in the amount of $230.92 to Walmart, and then he'd ask for 24 months to pay those outstanding fees and restitution before they're sent to collections and a civil lien.
Mr. Kelly, would you raise your right hand? Do you swear or affirm the information you're about to provide this court is the truth, nothing but the truth, so help you God?
Yes, Your Honor.
State in agreement?
Your Honor, the state is in agreement.
So, Mr. Kelly, you heard your attorney state the terms of your agreement,
Yes, Your Honor.
and I see you've signed the written agreement
Yes, Your Honor.
that contains those terms. Have you read this closely, gone over it with your attorney in detail?
Yes, Your Honor.
You understand that by entering this, you're waiving the right to go to a trial. This will be a final resolution of your matter.
Yes, Your Honor.
You believe that's in your best interest?
Yes, Your Honor.
Okay, and you're entering this freely and voluntarily.
Yes, Your Honor.
Based upon that testimony, the court will accept your plea. There'll be an adjudication of guilt on all counts. You'll get credit for time served. That's technically your sentence. And the court will assess court costs, public defender fees, and the restitution in the amount of $230.92 to Walmart. You will have 24 months to pay these court costs and fees before they go to collections. Question?
No, Your Honor.
Thank you very much.
You good with this? That's it. Your Honor, my last this morning is going to be number 40 on the docket, Richard Lane. If I can have a second with him, Your Honor.
Yes, what's a non female? That was my favorite. I think so.
Mr. Medina, who's got Dispinet?
That's probably Miss Farkas, part of the alphabet, Your Honor, now?
Because it's got Landon Maddox as the...
It's a little confusing, Your Honor.
That's
There's a
Rachel's case,
misdemeanor
Your Honor.
case. There's a
That's
misdemeanor
Farkas'
case.
Okay.
Your Honor, this is Mr. Lane before the court, trying to just figure out how we want to do this. I had a kind of an outline of what I wanted, but the state was, pulled me aside and addressed one of the issues, so that's moot at this point. Mr. Lane is actually before the court as a status. The court's well aware of the issues that we've had as far as trying to determine the appropriate jury instructions as well as sentencing guidelines. I've tried everything I can over the last couple of weeks to try and get an answer on specifically the jury instructions. I know the state, Mr. Law School, Mr. Jardine has done it as well. I know the court had basically said if there was an issue, you would help. I think we're at the point where we need the court to help us figure out the appropriate jury instructions, whether it needs to be the 1983, the 2024, or some combination of the two for an appropriate trial for Mr. Lane. My belief is that we at least need the 1983 version of the jury instruction for the charge itself, and then potentially use the 2024 jury instructions, but I also don't want to set it up to where we have to come back and do it all over again because we did something we weren't supposed to. So I think that...
Well, that's always a possibility if we don't get it right.
Yes, Sharon, I think given that we've got about a month left, I think that's one of those things, if we can try to get everyone, try to get an answer on that, I think that would be the best
So
thing.
how do you propose, I mean, what I would, if you're asking me what I would do, is I would ask, I think this would lend itself to actually some type of written, rather than, I don't know that you know, just presenting it orally.
Yes, sir.
It's right, so you know, if there's case law to really dig into it and,
Yes, sir.
and, you know, and try and do that. And then maybe on top of that, if we have to have a hearing, we can have a hearing for further argument. So why don't we file something?
Yes, sir.
And then get it on for some type of a short hearing if we need it.
Well, and I don't know that there's going to be arguments either way. I think the state and I are in the same position of trying to make sure we get it right. And
I understand that, but you know, what is right? That's the we're always trying to get it right,
Yes, sir.
and we're not just arguing for argument's sake. So I'm assuming that, but there may be disagreement, and may be a lot of people don't realize. And I'll just address it to your client. You know, everyone thinks that the law is black and white, and it is many times, but sometimes not so much. This stuff gets very complicated, and when somebody's liberty, which is what your situation is at issue, we want to try and get it right. You know, we operate under the same rules you do. It's called the rule of law. That's what we're trying to do, to figure out what the rules are and operate under, so everybody gets treated fairly. That's the goal.
Yes, sir. And I think that at the end of the day, we can file something, but
It was my recollection the court had basically said if the court can assist, let the court know this is where I'm saying at this point.
Well, kind of just let me know where we're at with it, and then
Yes, sir.
I'll
And
take a look at it.
from what I can understand, we need to, at the very least, the jury instruction for the charge from 1983, and more likely the newer stuff, because the old stuff wouldn't address.
What does the state, I mean, does the state have a position regarding this?
Your Honor, there is a copy that was scanned in that Mr. Losco had found. I will forward them to Mr. Gates.
I've got the jury instruction, as I said, the 1983, the statute for the sexual battery charge, I agree. I think everyone's on board. That's the appropriate charging instruction.
Gotcha.
The rest, the pre-instructions, the deliberation instructions, that's where I'm trying to figure out, do we need to do the 83 or the 2024? My position would be we should do the 2024 because the 1983 isn't going to include cell phones, new technology that I think that we would need to address. So that's where.
Well, I mean, as a general rule, you know, when you talk about jury instructions, the actual charging document, those are very specific. Those are the kinds of things that are appealed. But the other things, the instruction on shutting off your cell phones and whatnot, those are not mandatory. Those are, you know, as a matter of fact, different judges do it a little different, and some of them just ad lib on some of them. In other words, that type of precision of a charging document is not necessary. So I don't know that there's a right or a wrong way to do it.
Yes, sir. And that's where I've explained to Mr. Lane, I don't want to put him in a position where something goes wrong and now we're looking at an appeal.
Sure.
The other part of that is obviously the court's probably aware, back in the 80s, the defense actually had the sandwich. We would go first, the state, and then we would go again. Clearly that's changed. The state goes first, then us, and then the state. So there is some instructions on that, as I said, that I'm kind of in a gray area where I'm trying to figure out what would be the appropriate way. I've tried to reach out to the second DCA for an answer, and I haven't gotten one. And I know that the state had been speaking with Tallahassee as well to try to get an answer on that. We're as a status, we're trying to get an answer.
That's very significant.
I would say as a status on that.
So there are some procedural things that affect the substantive rights.
Yes, sir.
As opposed to kind of a process of how do we handle the trial. How you handle the trial, the judge, the court, we got some discretion, and different judges, as the council well know, handle things a little differently. Some of them handle it a lot differently, but that's not substantive. The substantive stuff is the stuff we need to first of all make sure and get right.
Yes, sir. And that was one of the points of the status today, was to let the court know that where we're at on that, we're trying. I'm well aware every court's different. I've tried a case in front of Judge Bell and in front of Judge Wells, so I've been on opposite ends of the spectrum on all that before. I just want to make sure as I told clients, we really only get one shot. We want to make sure we do it right. Today was really a status to try and make sure the court was aware we were at. And we're still trying to get all that answered. My hope is by the time we come on the 14th, it's all been answered and we're all on the same page on that. The other part was we filed a motion to compel in Mr. Lane's case. I talked with the state.
That's what I thought we were here on.
Yes, sir. And I thought the state has already told me that they're in agreement. They're going to try their best to get me that information. Mr. Lane had asked basically if there's a way to get some sort of transcripts of those hearings and a video recording. I don't know about the transcripts because our office may not pay for them because they're not considered part of the case. But I'll talk with the state to see about what we can get to get all that information for Mr. Lane so that he's got what he's asked for as well. And it doesn't sound like the state's going to fight me on any of that either.
No, and Your Honor, the state, we had reviewed the motion to compel and requested the exact information that Mr. Gates had requested. We've already been in contact with Las Vegas. We just need to get them to send us what we need, and it's been a little bit of a miscommunication between them.
Okay.
I don't know, but I'm going to try.
Okay. Well, looks like, I appreciate your all's efforts. This is a little more than a little more complicated than normal, so. And this is a high-stakes game because the charges are very serious.
Yes, Your Honor, and there was, obviously, there was the issue on the sentencing as well. Mr. Lane, I think I had told the court previously that my research basically had said that it was an indeterminate sentence, that the court really kind of had discretion upon further research. And in my spare time, I was able to define statute, and I've talked to Mr. Lane about this. It's statute, 1983 statute 775. I want to make sure I got it right because I had it pulled aside. 775, I want to say 083, but essentially the subsections underneath that specifically address the sentencing. 775082, I was off by one. If I can approach, Your Honor, just so the court can kind of see.
Sure.
I've given the state a copy of that. And this is one of those changes I had after court trying to get ready for this hearing. The highlighted section essentially says that a person who's been convicted of any other designated felony may be punished as follows: for a life felony committed prior to October 1st by a term of life or for a term of years not less than 30. So, and I've talked to Mr. Lane about this, it looks like, at least my understanding of the statute, if he is convicted, the court has to sentence him essentially 30 years to life. I know that that was a change from what I perceive to be an indeterminate
When you
sentence.
say 30 years to life, you mean between those two?
Yes, Your Honor.
Okay.
And
I agree.
And so that was something else I wanted to make sure the record's clear, because I told the court previously it was an indeterminate sentence, but it doesn't appear that way. It appears a statute, and because there wasn't guidelines back then, obviously, that's what the court would be required to do. Obviously, the guidelines for today have Mr. Lane scoring 10 to 12 years, which is a significant increase exposure, but I wanted that on the record as well. I think that's about it,
Very
Your Honor.
important.
I think that is it. If we can continue Mr. Lane's case to August the 14th, and then hopefully by then we'll have the information we requested and Mr. Lane will be ready to go. We good? Anything else? You sure? Okay. August the 14th, Your Honor?
August 14th.
Thank you, Your Honor.
I appreciate y'all's effort on this. I know this is a complicated case.
And I think that's all I got before the court this morning, Your Honor.
Thank you very much. Ms.
Your Honor.
Ms. Farkas, are you doing Dispinet?
Yes, Your Honor.
Okay, just wanted to make sure, because it's not, I don't know whose
It's
name.
not in the courtroom now.
I do not have any information as to his whereabouts.
Go ahead,
Your
Mr.
Honor,
Medina.
I have 4 or 5 inmates.
Okay.
First is Carson Ray Allen. Miss Allen is before the court, docket 41 in 22 CF 2031. It should be docket 41, Your Honor. Carson Ray Allen.
Thank you.
And, Your Honor, she is going to be evaluated for the 90-day program. If we could get an August control date, something like August 15th or something, hopefully she'll be in the 90-day program and that'll come off the docket. But she hasn't been evaluated yet.
How about August 20th?
Thank you, Your Honor. Okay?
Okay, good luck, ma'am.
Okay. Your Honor, I guess I need to clarify, just one second, ma'am, is that because it's the 90-day program, do they stay on the regular docket in the 90-day program? They do come off the docket?
They do come off the docket,
Okay.
Your Honor, and then they'll either complete the 90-day program or not, and on a felony, if they successfully complete it, well, I guess either way, they'll come back on the docket, either after they've been kicked out and placed back in the county jail for that bond violation, or if they've completed it, they'll be out of custody and come back on pretrial, the next pretrial conference after they complete the 90-day
Okay,
program.
and because she's from Mississippi and that had created a lot of problems, we're hoping to get her stabilized and getting treatment as needed, and then we'll go from there, and hopefully we can have good success in the 90-day program she gets in. So in the meantime, you're on August 20 with Judge Ketchel. Okay? And you'll probably get another court date if you get in the 90-day program. Yes, ma'am. Thank you. Thank you, Your Honor.
Thank you.
Your Honor, Steve Medina with Calvin E. Baker, 24 CF 225. Mr. Baker is on the docket for a motion for bond and a motion to compel. Your Honor, can I have a moment of the court's patience to talk to the state very briefly? We may have a ability to resolve things. One moment. Your Honors, okay. Your Honor, may we proceed with the motions that we had filed? One was a motion to compel that's quite simple, and then there's a motion for bond reduction that in part ties into that. Basically, in our motion to compel, we mention lack of some Leo video, law enforcement officer video. We continue to lack Deputy Sheriff Sean Murphy's video, and that's important video because he's the person who did the search of the defendant's person that found some alleged contraband, and we need to get that in order to complete our pretrial preparation. Also, Casey Dew, I apologize if I've mispronounced, but that deputy sheriff, we're not sure that he had video, but if he has video, he apparently was on scene. There was a reference to FDLE chemical analysis. We do now have that chemical analysis, so that part of it is a moot. But Leo video, especially on Deputy Sheriff Sean Murphy, is very important to pretrial.
Where are we at? What's the state's?
So, Your Honor, there was some video that he asked for in the motion. I believe it was Deputy Morton. I did confirm, and I did look at the video we had, re-look at the video and confirm that he does have that video. I have asked for the video of Deputy.
No, he said Murphy.
I have asked for that video. I was about to let the court know. I have asked for that video. I do not yet have it. As soon as I have it, I will.
Is it out there?
Just let me do my.
They should have videos, Your Honor, and I am requesting those videos. So I have requested them. I do not yet have them.
Okay, so what does that mean? You know this process a little better than I do. I mean, why,
So
if they've got them, they give them to you. What's the whole, what?
It could be mislabeled. I don't know why it was not given to me originally, but
When was this request made? When did you request the follow-up?
in the last week, Your Honor. I had to go back through theevidence.com and make sure that everyone's video was labeled correctly.
Okay. So I'll grant the motion to compel.
Your Honor, if I may.
I mean, you're saying you're trying to comply with it anyway.
Yes, Your Honor. The state has no problem with the motion.
Your Honor, just to clarify, would the state be able to provide the video within 15 days?
She doesn't know.
Oh,
The way she just said, I was pressing. I mean, you heard me talk.
Oh, I understand, but granted, and the state shall make every effort to provided.
Provide it immediately.
Provided
As soon as,
immediately.
as soon as they can find it. I mean, I'm assuming that if it's lost, in other words, there's a problem, they're going to do their best to do it. I don't know what that means. I mean, I'm taking them at, their good faith. Everyone understands it's got to be provided.
Yes, Your Honor, it does have to be provided, and as soon as I do have it, he will get it. And I think 15 days should be long enough. If there are issues, I will advise Mr. Medina, and if we need to advise the court of any issues, we will let the court know that.
Okay. Did you hear that, Mr. Medina? To let
Your
you
Honor,
know.
I'm sorry, but
That's all right. No, she just said if it can't be done in the next 15 days, she'll be communicating with you and figure out.
I didn't mean to be disrespectful to the court.
You weren't.
Or
You weren't.
Or to my client, but he's whispering a lot of information.
Yeah, you can't do two things at one time.
It's very difficult.
Impossible.
He's disappointed because we haven't been able to work out the case on the merits, but the second motion is the motion for bond, Your Honor. And that in part ties into this outstanding evidentiary issue of not having critical video. There also are other issues, Your Honor. He has a $12,500 bond that he financially can't make. This is his first motion for bond reduction. Moreover, in reciprocal discovery, we have filed additional materials that show significant questions on 2 of the charges, and there's also a drop charge request relating to the grand theft auto by that alleged victim. We have depositions set forth to proceed. I think that the depositions are July 30, if I'm not mistaken. And so we would ask that the court grant Mr. Baker a bond reduction.
What are you asking for?
Your Honor, he's asking for a reduction to a total of no more than $5,000, which would be $500 to a bondsman.
Is that for one of the counts? You've got 4 counts.
Your Honor, it would have to, that would be the total, so we would ask to split it up in I'm sorry, Judge, there's...
We'll work that. What's the state's? Is the state okay with?
Your Honor, so no, the state is not okay with reducing the bond to a total of $5,000. Your Honor, the state, to Mr. Medina's point, the state would not oppose a reduction in the bond on the grand theft of a motor vehicle count only to a simple signature bond, but that's the count that only has a $1,000 cash or professional bond as it currently stands, so I don't know that that's going to make much of a difference in the bond. There is still outstanding a $10,000 cash or professional bond on the possession of ammunition or a firearm by a convicted felon.
I will tell you that, and I'm open to hear this because maybe I don't understand the full context. Court's got at least some questions as to why, 6 months into this, because he had a first appearance back in January, 6 months into this case, just last week, you're asking for video from law enforcement on a clearly evidence that is relevant and maybe critical to the case, and it's just being requested last week. I got.
Your Honor,
am I off base with that? That's directed at the state.
I'm sorry.
Your Honor,
I mean, if it's unreasonable, I'm open. I'm open to hearing.
so to explain how body camera works, the officers simply dock their body camera and it gets uploaded for them. If they mislabel it or if it's not labeled at all, when we go to request the video, the evidence.com case that gets sent to us from the sheriff's office does not always include mislabeled or not labeled videos. So you have to get in touch with the officer, find out if they have video, and they have the whole case reshared. So it's not like just an easy process to get body camera that wasn't originally included, and it does happen.
And that process takes 6 months.
No, Your Honor. It was brought to my attention, I think, in June or May, that he didn't have videos, and when he was looking through the videos for the upcoming deposition, so
Your Honor, it was May 13th that I referenced in the motion.
Yeah, but the state has an obligation to review the evidence as well. It's not your obligation to point out to them that they're missing video cam when it's obviously relevant.
May I clarify two other things, Judge, for the court's consideration?
Yeah.
The contraband that was originally suspected fentanyl came back as clonazepam from FDLE that I just got, I think it was yesterday, the production on that. So I just wanted the court aware that...
Is that one of the charges?
Yeah, yes, Your Honor. One of the controlled substance charge is not for fentanyl. Just in case the court was interested in that level of detail, is that it is for clonazepam, which is...
What is the possession? What are the allegations as to the possession of ammunition?
That I was going to say, Your Honor, that was 2 alleged bullets. 9mm, I think they were blazer bullets, and that's why those allegedly came out of his pockets, as well as controlled substances. So that's where, when I've carefully looked at the other officer's video, and you really can't see what's happening there. So we have a right to that video. It's very important to see what it shows. I know that it can be complicated for the state, but really it's complicated for him to not have his freedom. That gets to the last part of this, and maybe he wants to testify, Your Honor, because this is his first bond motion, without talking about the facts of the case. But can he testify as to the basically what this situation of not having his freedom, all the financial and family burdens that this is causing for him? Can he testify to that, Your Honor? It's not necessary? Thank you, Your Honor.
Court will grant the motion. Court's going to have $2,500 cash or professional bond for count 1 and count 3, and counts 2 and 4 will be the paraphernalia will be an ROR bond, and the grand theft will be a $1,000 signature.
Thank you, Your Honor. And, Your Honor, can he be...
Did you get that?
I have 5 counts.
What's the 5th count?
Could he have a ROR on the 5th count? That's one where we have...
The misdemeanor, yes.
Misdemeanor ROR?
Yes.
Okay, on count 5. Thank you, ma'am. Your Honor, 2 other things is he would remain on could he be on the August 12 docket since he'll be out of custody?
Yes.
Hopefully, if he can post bond. And the second thing, Your Honor, is I would respectfully ask the state to keep his offer open because I am doing depositions that will hopefully take place before August 12. Further, we may be getting video from Deputy Murphy that may help in the assessment of the case. So I would hate for him to have to make a very serious decision without having benefit of the depositions and all of the evidence if it can be obtained. So I would just respectfully ask the state to keep the offer open until
next pretrial.
Yes. Okay. Okay. Thanks. Thank you, Your Honor.
Thank you.
Yes, sir. Thank you. Thank you. Your Honor, Steve Medina with Antonio M. Betts in 23 CF 483. Mr. Betts is Bell Betts in the docket at docket 44.
And Your Honor, the defense has filed a motion to compel, and the state does not object to that. In fact, the state has received and sent most of this evidence already. I don't know if Mr. Medina has had a chance to review that, but I don't object to it in the entry of an order.
Very good. By stipulation, the court will grant the motion.
Your Honor, and will there be basically it's the, I apologize, but for is it like with all deliberate speed? I'm just trying to. As soon as
15
possible.
days?
15 days, Your
15
Honor,
days.
and then again, if there's issues, I will let Mr. Medina know that, and if we need the court's assistance, we'll let the court know.
Very good.
There was one other procedural matter, Your Honor, that I had to notice the FDLE. There was a sound expert who worked on the audio related to the law enforcement officer's videotape. And I could not get a deposition scheduled with him until September. And that's going to cause this to be pushed off another cycle. In order for me to take that deposition, I would just simply ask, is there any possible way that we could do that deposition quicker?
Your Honor, I don't know that off the top of my head. Ms. Buhal gives the closest deposition dates I have. If there's a Friday afternoon or something that will work for the
If you'll just make an effort to do it.
I'm just saying, Your Honor, because otherwise.
If she said she will try, and I'll allow you all to continue.
So for now, we'll remain on August 14, and we'll try to get it done before then if we can get a date.
Okay.
To renotice.
So we will continue this till the 14th, if it's not on the calendar already.
Thank you, Judge.
Your Honor, Mr. Betts, against my advice, wants to address the court. I'd advise him not to discuss.
Would you raise your right hand? Do you swear or affirm the information you're about to provide this court is the truth and nothing but the truth, so help you God?
Yes, sir.
Go ahead.
Your Honor, I'm very understanding that he's doing more depositions. I just asked him what of the evidence that we already have, the depositions that clearly prove that there is misconduct in law enforcement, and I don't understand what's taking it. So I've been in jail for 17 months. He's still doing depositions. He wants to do depositions on the guy that edited the video. Is he looking for a lesson on how to edit a video? Is he?
Well, the problem is that you've got 9 counts, and these are very serious charges, and you've got to look at all these things before you can kind of figure out how to proceed. This is a complicated case. That's the short answer to your question.
Yes, Your Honor.
Yes, serious case. One of them's attempted homicide.
Yes, Your Honor.
Aggravated battery and unlawful. These are very, very serious charges, and you know.
I understand that, Your Honor.
Everyone's trying to be thorough, especially defense counsel.
I understand that, Your Honor, but I've given him numerous case laws. I've given him, it's to the point I don't understand what he's doing anymore. Like, for instance, the first sentence in my arrest report is a lie. They
So
say
what are you asking for?
Relief from him.
Relief from him? Well, then
Yes.
file a Nelson hearing, and we'll have a Nelson hearing.
Because
You think he's not doing his job, and we'll talk about it.
That's it, Your Honor, because
file it.
I've
File
given
the
him-
Nelson.
I've given him, like I said, I've given him case law. I've given him
Did you hear me?
screenshots. Yes,
Did
sir.
you hear me? Okay, that's your answer.
Your Honor, so Mr. Betts is going to file a written Nelson motion if he wants to air his alleged inadequacies of my counsel, and then I can appropriately
Address it.
testify and address it.
Okay.
Thank you.
Very good. There's a process for it.
Yes, sir. Thank you, Your Honor.
Thank you.
Right. That he had a private lawyer It's been my case since December.
Which one?
Mr. Bowser.
He did have a private lawyer for a good amount of that 13
Oh.
months or
That's
whatever.
correct, Your Honor.
But in any event, moving right along. Your Honor, Steve Medina with Mr. Daniel Daniel B. Bertram. And Mr. Bertram has an agreement in, it's docket 45, Your Honor. And his case is 23 CF 2000. And he is signing the agreement that we've been over, Your Honor. Yes, sir. Your Honor, I'm approaching with the signed agreement and with the score sheet, Your Honor. We don't have any questions about the score sheet. It is going to be a downward departure as a legitimate uncoerced plea bargain, Your Honor. It's going to be a revocation of his probation. May I approach?
You may.
I have a copy for probation. Even though it's very simple.
Would you announce?
Yes, Judge. Thank you. Your Honor, in 23 CF 2000, Daniel B. Bertram is pursuant to agreement admitting the violation. He was previously adjudicated guilty. It would be revoke and terminate supervision, 10 months Okaloosa County Jail with credit for all time served, $100 VOP, 150 public defender fees, outstanding monetary obligations to collections or lien 6 months after release. I don't know if he has a VOP, I don't know that he has an FTA, but in the event that he did, the state would not be charging on any FTA.
State.
That's the state's agreement, yeah.
Mr. Bertram, would you raise your right hand, sir? Do you swear or affirm the information you're about to provide this court is the truth, nothing but the truth, so help you God?
I do.
Mr. Medina, you okay with the score sheet?
Yes, Your Honor.
Okay. So, Mr. Bertram, you heard your attorney state the terms of your plea agreement, and I see those same terms are on the written plea agreement you've signed.
Yes.
Just want to make sure you've read this closely and gone over it in detail with your attorney.
I did.
You understand that by entering this, you're waiving the right to go to a trial. This will be a final adjudication of this violation of probation.
Yes, sir, I did.
And you believe this is in your best interest.
Yes, sir, I did.
Based upon that, the court will accept your plea. You were previously adjudicated guilty. The court will revoke and terminate supervision. So probation will be completed. You're sentenced to 10 months, Okaloosa County Jail. You will get credit for all time served. And there's, of course, the standard fees and costs. You'll have 6 months after you get out of Okaloosa County Jail before it goes to lien, and the state will not proceed on any failures to appear.
Thank you, sir.
Question? Good luck, sir.
Good luck, Mr. Bertram. Take care. Thank you, Your Honor.
Thank you.
Your Honor, Steve Medina with Malik Ramir Bradshaw, 46 on the docket, I believe, and his cases are 21 CF 2374, 23 CF 1031, 23 CF 2658, and 23 2660. We're here on a defendant pro se motion for Nelson hearing. I must say that when I get a super vague motion like this, I don't have any way of knowing what it is he's directing at.
So we'll see if we can clarify a little bit. So, Mr. Bradshaw, would you raise your right hand, sir? Do you swear or affirm the information you're about to provide this court is the truth and nothing but the truth, so help you God?
Yes, sir.
So, Mr. Bradshaw, this is what's called a Nelson hearing. So the first question I have to ask you is to confirm that you want to dismiss your client, your attorney?
Yes, sir.
Okay. Now, you have an absolute right to dismiss your attorney. Okay?
Yes, sir.
The question, though, that the court has to detail is whether or not the court would then appoint another attorney for you.
Yes, sir.
Okay? And that's based upon whether or not your attorney has not adequately represented you.
Yes, sir.
Okay? And so my question to you, and it basically takes off a little bit from Mr. Medina says, what exactly are you complaining about? What ways do you believe that your attorney is not adequately representing you? And be as specific as you can.
Yes, sir. Well, thank you for allowing me the time to address my issues I'm having with my legal counsel. I know I have the right to effective legal counsel in a criminal proceeding. I also know in all criminal prosecutions.
Sir, answer my question.
Yes, yes, sir.
I'll give you a chance to talk. What?
I would ask two things. Number one is, I'm not sure he was put under oath. Maybe he
I did.
was. I apologize. Yes.
That's all right.
The second thing is that I just want to make sure that he knows if he addresses issues of attorney-client confidentiality, that I have a right to respond, and it might involve giving attorney-client confidential information, work product, et cetera.
Okay, it's a good statement. Do you understand that, Mr. Bradshaw?
Yes, sir.
Okay. So what specifically?
I feel like that my lawyer is not competent enough to handle my case, Your Honor.
Why?
Because I have multiple times addressed it, many things that I know that is in my case that is wrong, that he had failed to.
You got to give me specifics.
Your Honor, if I may, can I address these documents to your attention?
What are they?
They are a falsified statement by a police officer in my arrest report.
Okay.
Your Honor, I would just caution the defendant to not discuss the facts of this case, whether he wishes to accept mine.
It's up to him. You want to show me that? You going to reference something in there?
Yes, sir.
Okay.
Your Honor, can I see what he's trying to
Sure.
provide to the court, please?
Would you show it to the state?
Your Honor, may I be seated while he proceeds, if that's okay?
Sure.
Thank you.
Your Honor, the state doesn't
Okay.
object
No,
to
no,
the
no.
court reviewing this.
So you just handed the court an incident report. I assume this is from your original arrest?
Yes, sir, and also an arrest report.
Okay. So there's more than one, well, I mean, there's several pages.
Yes, sir, it's an incident report and also an arrest report
Okay.
that was made by the arresting officer.
Okay, so what is it that you want to draw? What is the point you're making?
Well, Your Honor, I have discovered a very vital issue in my November 25th, 2023 case as to where probable cause for my continued detention is upon a falsified arrest report stating under oath by the officer that I rented a firearm from the Emerald Coast Indoor Shooting Range
Is
on
there
the date of
some
my
place in
arrest.
here that I'm supposed to be following along with that?
Yes, sir, I have key points in there that is highlighted in there, yes, sir.
So you've highlighted them in these?
Yes, sir, I underline them.
Okay, where are we at?
The statements by, where the officer said that I rented a firearm is key one that's underlined in my case.
Is this the page? I'm not sure. I'm not sure what you're.
I underlined them and I had put key points by.
It says suspect left his Florida ID card.
Yes, sir.
Is that the sentence?
Yes, sir.
Suspect left his Florida identification card with the employees due to renting a handgun.
Yes, sir.
From the facility, along with bringing one of his own.
Yes, sir. And also in the physical evidence, what the officer has said does not match what he had stated, which is a false statement in my case, because I never once rented a firearm or a handgun from that facility.
Okay. Okay. Anything else?
Yes, sir.
So you think that this goes to the, okay, well, we'll kind of look at that a little more closely.
Yeah, if I can I please continue with
You may.
what I have wrote down?
Sure.
A probable cause to continue my detention upon a falsified report stating under oath that I rented a firearm from Emerald Coast Indoor Shooting and Sport Range on the date of my arrest. That would be impossible to do as I am a convicted felon and the background checks are done as well as a signature of a waiver before anyone can rent anything of as such. Clearly in this case law of State versus Bernie, 472 SO.2D 1243 Florida, .2D, DCA, 1985, police officers...
So you're still focusing on this one sentence?
Yes, sir. Yes, sir, I am. Police officers know that an oath requires the declarant to render himself punishable for perjury for any false statement. It is against the law for anyone to falsify a sworn affidavit in which grounds for dismissal, in my case, that is visible of the face of the court records. But Mr. Medina hasn't even mentioned a word about it and has had the said reports in his possession for the last 8 months. Due to these facts alone demonstrate that he has no vested interest in my case, and therefore I feel like that it is necessary for him to withdraw from my case because I feel like he is not taking my case seriously.
Okay. Mr. Medina.
Your Honor, I have, the record would reflect notice for September 10, 6 depositions in case 23 CF 2658, which is the third of Mr. Bradshaw's cases that he's referring to. If, based on those depositions, I see a meritorious basis for any motions, I'll certainly be...
So what you're saying is you're not necessarily disagreeing with him. You're saying you're pursuing this by taking depositions, putting the officer under oath, and basically trying to figure out what's the situation.
Yes, Your Honor. I'm trying to sort out the facts. Okay. At least see what the officer's testimony would be. Very likely it's discovery related to trial preparation, which needs to be done no matter what. But in the event that there was a basis for a motion that came forward from the, what happens in the depositions, I'll certainly give it consideration. I don't have a basis at this point in time, Your Honor.
Okay.
May I speak, Your Honor?
Mr. Bradshaw?
Your Honor, I have been incarcerated in county jail for 8 months now. Mr. Medina has been appointed to me since December of last year. I understand that things work at a steady pace, and I know that...
They don't work at a steady pace. They work at a slow pace.
Yes, sir.
We all acknowledge that. I'll grant you that. I'll give you that.
But also, the things that I have pointed out to him, this is not the only case or things that I have pointed out to him involving in my case.
If you got something else, you need to let me know.
Yes, sir.
We need to get down the weeds on this now.
Yes, sir.
Now's the time, and this isn't vague. Hey, I've been telling him all kind of stuff, and multiple times he ain't doing anything. That ain't getting it.
Yes, sir.
If you got something, you gave me something very specific, he responded to it. If you've got something else, give me specifically what it is that you believe is an issue.
Yes, sir. Well, currently I don't have the rest of the things that I have pointed out, but just him being my legal counsel, I have lost confidence in him as an assistant.
That in and of itself isn't grounds. Well, again, you have a right to fire him.
Yes, sir.
I'll fire him today. You're not required. The question is whether you're going to get appointed another counsel.
Yes, sir.
Then the question is, based upon, so anyway. So anything else that you want to, any specific instances that you want to thing that you think he hasn't adequately provided representation on?
Now put in the proper motions to move forward in this case.
I'm sorry?
Put in the proper motions to move forward with this case
I don't understand what you're saying.
by basically prolonging this case.
What specifically do you mean? I don't know, I'm not understanding what you're saying. Just some general, hey, he's not proceeding as fast as you believe he should?
Yes, sir.
Okay, that's too vague.
Yes, sir.
Okay. Anything else?
No, Your Honor.
Okay. So here's the situation. First of all, look, I'm going to share with you.
Yes, sir.
I understand your frustration.
Yes, sir.
So I'm frustrated too. And not only that, you're frustrated and you're in an orange jumpsuit. You're in jail. I get it. You want things to move fast? We want things to move fast.
Yes, sir.
They move too slow. Everyone said, every professional in this courtroom, if I asked them to raise their hand if they think that this process moves too slow, every single one of them would raise their hand.
Yes, sir.
Okay? But at the end of the day, that's, it's not anybody's fault. We're working the system as much as we can, or if you think he's not, okay?
Yes, sir.
But what you specifically said, he acknowledges may be an issue.
Yes, sir.
And he is pursuing. As a matter of fact, he's telling the court, he already has depositions scheduled.
Yes, sir.
And you know what he's supposed to do when he has an issue? Schedule depositions.
Yes, sir.
Okay? Because if you go in there waving your hand and say, this ain't right, and he hadn't done the depositions, he's blindsided.
Yes, sir.
You know what that is? That's incompetent.
Yes, sir.
So if he would proceed without this, he wouldn't do it. So based upon what you're telling me, he is not improperly or inadequately representing you. So what that leaves you with is this. As I started this thing out, I said, you have the right to fire him, but you're going to be going alone if you want to do it. So if you are thinking you're going to want to go it alone without an attorney, I have some other questions I need to ask you. So what are you thinking at this point?
I'm not able to go along in this case.
Okay.
I would
Well,
need a legal
that's a smart decision.
Yes, sir.
Do you want to file these with the court? With the court file?
Yes, sir.
Okay. Court stayed okay with him with filing these? Court will file this as composite defenses, composite exhibit 1.
Yeah, Your Honor, may I just, in the event that defendant may want it later, the public defender, we've used our copy machine, we provided him a copy of his discovery. I don't think it really is going to serve any purpose in the court record. He may want to hold on to it.
Do you have an extra copy? Is that an extra copy?
No, sir. That came with my discovery.
I think it's clear what they are.
And we read it into the record.
He just may end up learning to hold on to it. Your Honor, may I also say a couple of other things, Your Honor?
You may.
I also, in one of the other cases, have deposition scheduled. In the third case, I've done a significant amount of work, and feel very comfortable with what I've done heretofore. There are some issues of discovery that I've been pursuing with the state, and just yesterday, I received some written discovery from the state. I made an extra copy, so I'm giving him what I got from the state yesterday. So that's one of the other things I'm doing to get ready for trial and try to pursue discovery issues. I'll come and meet with him again in the near future, Your Honor, and we'll go from there. So if he can
Has the
remain on-
state determined which case they want to proceed to trial on?
Your Honor, we'll likely pursue the oldest case first. That would be,
The 21 case?
I believe that's a violation, Your Honor.
Yeah, not the 20, I did not state the 21 case, that is the VOP, Your Honor.
So, Your Honor, we'll proceed with the violation.
I'm not going to hold you to anything, I'm just asking.
We'll proceed with the violation first, but at least the violation and then the 23 CF 1031 case.
Gotcha.
Your Honor, many times evidentiary hearings are more or less mooted through admissions on technical grounds. For instance, I would basically point out that I have not had a chance to assess what came in yesterday, but there are significant discovery issues as well as depositions set in that very first of the 3 cases. So
Okay.
I'm certainly not giving the impression that we will for sure be ready for trial this cycle, but I'm doing my best.
Okay, very good.
Thank you.
Thank you very much. Okay, Ms. Farkas, you got a couple cases.
Your Honor, there was one
Is there
other
somebody else in the courtroom, counsel? You looking for somebody?
Can I just put one thing on this?
Sure.
Advise the court of something, with the court, if the court's okay with it. I had asked we can work out a case, actually 3 cases of a person who's in jail. It's a burden to the taxpayers of Okaloosa County, so we're trying to get Donnie Bray.
Is this on the docket?
They
Or
can't
is this
transport him. It's not on the docket, Judge. We just figured out a way to get him out of jail with a reinstatement. So I don't know of any way, I just didn't want him given the medical issues, to stay in jail until August.
Are you asking if he can be transported for this afternoon, maybe?
I think
I
it's,
reached out and detention said that they weren't going to be able to make it happen today.
is there
Why don't we do it tomorrow?
That's fine with me.
We're doing that other case at 1:30? We'll do it at 1:30. I'm sorry, is that?
Miss, could somebody else cover it though? I don't know if it's just a DOT deal.
I will ask if someone else can cover it. It would be better if we could wait till maybe Thursday when we're here for pretrial detentions, but
Oh, pretrial.
It's fine with me. Your
That's
Honor.
fine. You got-
Could he come at 12:30 on July 18th?
I would prefer
Thursday?
That's fine. Do we have a case number for the clerk?
Judge, I don't have the case, but it's Donnie Irvin Bray, I-R-V-I-N, middle name, Donnie Bray, B-R-A-Y, and he has 3 cases, to my knowledge, they're all DOTs, and it will be resolved. We're more or less.
Hold on, let the clerk find
you
it.
have the case numbers.
I don't have the case, I didn't read
I
them.
gave you this portion.
Okay, I have the case numbers.
Okay, I have them all. I'll send for Thursday at 12:30.
Okay,
Thank you, Your Honor.
12:30.
Appreciate it.
Okay. Ms. Farkas?
Yes, Your Honor. I believe my only outstanding client from this morning is Zachary Dispinette.
What about Carl Flack?
Oh, didn't know that he was on the docket for this morning. Yes, Your Honor. Yes, I remember. Carl Flack, 23 CF 1221. He was here this morning. He was released from booking and was sitting here all morning and then was rearrested on petty theft charges, unfortunately.
Oh, that was the one.
Yes, sir.
So
So I'll enter a denial on his behalf. That's what we were planning to do.
that's fine. We're in a denial on today's case, 23 CF 1221. That's a good idea.
Thank you, Your
And
Honor.
then we'll come back. We're going to run all the cases together, come back on 820?
Yes, Your Honor.
Okay.
I think he'll probably go to first appearances for the new case tomorrow morning, and then
That's fine.
we'll go from there.
Okay. Dispinette?
Yes, Zachary Dispinette, 22 CF 745. Mr. Dispinette accepted a plea, or he took a plea in this case and was meant to begin serving his 6 months OCJ today.
He was actually going to be sentenced today, right?
Yes,
Yes, Your Honor,
yes.
he's-
So he
he's-
pled guilty.
He's already entered a plea to the court, and he was made aware that any failure to appear or any new law charges would result, and that being an open plea to the court, Your Honor, he is not here. The state would request a KPS issued for his failure to appear here today.
Any legal objection, counsel? Court will
No,
enter
Your Honor.
no bond KPS for Mr. Dispinette.
Thank you, Your Honor. There is one issue that Ms. Sharpless and I discussed, not a matter on the docket today, but something that we were hoping to put on the docket for Thursday.
Okay, hold on a second, let me.
I can wait, I believe, the jail, or there's another inmate, so I can wait to address those matters.
That's all right, no. Just trying to get organized here. So what is it?
Your Honor, Deidre Crowley, 24 CF 314. Her next court date is August 12th, but Ms. Sharpless and I have reached an agreement that will get her out of jail. So I'm hoping that we can put the case on perhaps Thursday pretrial detention, or really any time, just to, because she'll be able to get out.
Okay.
If
So-
there's time, I don't know.
Just so you all know, when we have these pretrial detentions, and they're the only criminal cases, the pretrial detentions, that's not the only cases that's on the court's docket.
Right.
I have civil hearings all day that day. Don't assume, well, we got the rest of the day open, we'll just slip this one in, and,
Yes,
you know,
right.
that's no big shakes, you know, it's 10 minutes, so.
Right.
It's right in the middle of the day. So,
Right.
so
I would also
I
be
will
able
try to
have-
accommodate, but,
I understand.
you know, if you
I
can
would be
find an
able to come
alternative
tomorrow.
day is better.
If
But-
we could put her on the docket tomorrow, that would work fine. If
But she
it's-
can't make it.
Your Honor, I'll have someone.
So that'd be better for, at 1:30 for tomorrow. We're going to be here tomorrow, and I actually do have a little more time tomorrow because,
Okay, I'll make sure that the
Somebody
jail
else didn't-
is made aware.
what's that?
Do we have the case number?
Yes, 24 CF 314.
If I may be excused, I think we're done.
Are we done? I think we're done.
No, Your Honor, Ms. Croxton.
Oh, okay, you're done. Thank you.
And Your Honor, that is 24 CF 1861 and 24 CF 1523. It's my understanding that while I was out of the room briefly, that Ms. Croxton's case was called, and she does want to accept the state's offer to admit the violation of probation and plead no contest to the new charge she has, and then come to a probation deal that would result in a bars to bed Keaton situation. But it's my understanding that she hasn't been accepted to Keaton. That's the state's offer. That's what probation also wants for her, but I don't have a Keaton acceptance for her yet. So I do need for her to be accepted to Keaton before we can make that deal. Obviously, I can't do a deal when I don't know she can go to Keaton.
Sure.
So, Your Honor, the only thing to do today is to either leave her on August 20th as a pro se defendant, or leave her on August 20th and ask her if she, I know she said this before, but ask her if she would like the assistance of the public defender if she qualifies, that gets people evaluated for Keaton all the time and can assist her with that, if she qualifies for the public defender.
Would that, does the public defender have the ability to kind of push things a little bit more than?
Your Honor, we do that all the time. I have
They're-
investigators.
They're investigating.
So you want an attorney?
Sure.
Okay, so court will appoint you an attorney, and we'll come back on August 20th.
And
And
Your Honor-
hopefully, you know, if we can do something in the interim, you know, we can come on a pretrial day or something.
Yeah, that's fine, Your Honor, this is a violation, but if the court doesn't mind, if we get something before August 12th or August 14th instead of August 20th, if we want to put her, if the court will allow us to put her
Sure.
on an earlier date, I don't
Okay,
mind doing that.
we'll try and do that if we can, to try and get it done earlier on.
And Your Honor, just for the court's and Ms. Croxton's edification, this will be a bars to bed situation anyway, so I would anticipate that even if she had been accepted to Keaton today, that she wouldn't be getting out today.
Right.
So I know it delays it for another month, but hopefully not too much longer.
Yes. Okay. So, that will, that's all we've got for today.
Until 1:30.
They were here for her.
Okay. Very good. So we'll be back, reconvene at 1:30.